Orders item 9.
Okay. So according to them, it should have been circulated in the locality newspaper.
Yes, my lord.
Okay.
But there was no local newspaper.
Okay. Then number 3. Deceased was not Indang.
That is what they're trying to claim. They're trying to claim their property as their own. However, the
Now, all of you were staying together?
No, my lord. They were staying at Electric Van, and we were staying at Zoang Tui. After the death, they forcefully entered our house and chased us out.
Then where is the impugn order now?
The impugn order is just after the index, my lord.
What is this page, Roman 10?
Roman 10.
Yeah, the impugn
Paragraph
order.
number 10.
Page Roman 10 and paragraph number 10.
Yes, my lord.
It
This is
says
the-
court's
this is-
order dated 11/12/2023. What is this?
11.
Because your application was
Resolution of this court
in
order.
2024.
This will be the initial order of the heirship certificate, my lord. Directing the appellant, who is the applicant therein, to take steps by way of newspaper publication.
Is it
notice.
available here? in this
My lord, that I have not enclosed. my lord.
compilation?
If so required, my lord, then records may be called.
It seems there's some direction here, as per the judgment.
Yes,
It says that the direction was given to publish in two newspapers, one
newspaper.
state and one in Zongti locality.
Yes, my lord. And however, Zhuang Tui does not have a newspaper circulating in their locality, so it becomes impossible. And this was duly informed before the trial court, my lord. In fact, the acknowledgement is at page 72, my lord, stating that at the time when the heirship certificate was applied by the,
Page 72.
page 72, my lord.
72 is what?
Acknowledgement of the chairman, Zhuang Tui Local Council,
Ah.
stating that at the time when the heirship certificate was applied by the appellant, there was no local newspaper circulating in Zhuang Tui locality. So it becomes impossible, my lord. Nevertheless, my lord, whether they have gained knowledge or not, the question is with regard to locus standi, my lord. Can they go against the act that is the reason for our appeal? Fathers have not been mentioned as a list of heirs, and sisters will only come if there is no wife, no sons, no daughters, and no illegitimate sons or daughters.
17.1 does not reflect the same.
My lord, the reason we are aggrieved is at the last sentence, my lord, of page Roman 10.
No, this basically is an observation, that's all.
My lord,
We'll clarify that, Mr. Counsel.
yes, my lord.
We'll clarify that the learned trial court concerned will consider all the relevant aspects as provided in the
My lord.
Inheritance of Property Act to come to a conclusion. And the issue of the observation that they have locus standi will have to be decided in accordance with that provision.
My lord, then my case will be delayed. Then I will be forced outside during all those periods.
No, we'll give some time frame.
My lord, time frame. My lord, my only question is whether this act can be bypassed. Because by this logic, even my neighbor can dispute my property. Because the father is not even mentioned in the list of heirs. Then
There is no shortcut, Mr. Zoram Chana.
Yes, my
Please
lord.
understand.
Yes, my lord.
I understand you're trying to establish the fact that this is wrong and it's in violation of Section 31, Clause 1 and 2. So it should be set aside. My heirship certificate should be upheld. So now, if now that two persons have come
Two
before the
persons have
court,
come.
two persons have come, so let them also project their claim And let the
My
court
lord,
decide.
Their claim has been projected in their review petition, saying
No, that is not sufficient. That is only for recalling the
Yes, my
headship
lord.
certificate.
They have said that they have contributed the money, but whereas the sale deed says otherwise. The
You
sale
prove
deed is
that.
at page 16.
You prove that as per law.
My lord, it's already proved. They are not disputing. They don't have anything to show that they have contributed the money also. In fact, what they should have done is they should challenge the sale deed, my
No,
lord.
you have not proved anything, Mr. Counsel. You
My
have
lord-
just simply submitted an application with all these documents, and court has said that, okay, you issue an advertisement in the paper, and you have issued advertisement in the Wanglaini Daily.
Yes, my
And since Wang Tui does not have a newspaper, he could not do that. So court accepted, okay, you have published, nobody has come now, issue. That's
My
it.
lord, it is an admitted fact that I am the wife. They have not disputed that I am the wife.
You say that before the
No,
trial court counsel.
I already said it, but if this review petition is to be allowed, then the act would have to be amended, my lord, because they would have locus standi. What I'm challenging is that, my lord, if I may read in the last sentence of page Roman 10, my lord, it is in my considered opinion that the omittance in the order dated 17/1/2014, coupled with the fact that the petitioners are the father and the sister of the deceased, are therefore having locus standi to file the petition.
Okay.
So what I'm challenging is the locus standi, my lord. In terms of this act, the father is not in the list of heirs. The sister will only come after if there is no wife, no sons, no daughters, no children. And if they are to have locus standi, then this act would have to be amended, my lord.
Okay.
Because by this logic, everyone can dispute the title, the heirship certificate. Because I was not given notice. That cannot be allowed, my lord. And my lord, if your lordship then allows, I will bring some authority. Because in Hindu succession...
You bring now.
My
We are
lord,
hearing the matter now.
yes, my lord. In the Hindu Succession Act, the class 2 heirs are not allowed to dispute the class 1 heirs if they are living. That part I have not got a copy with me right now, but as per the prevailing law, my lord, this
Wife is the class 1 here. Under the Hindu section, under the Hindu
the sons,
law,
yes, my lord, the sons and the children, the
sons
wife.
and the,
Yes, my lord. My lord, that I will bring, my lord. I am not quite thorough with that at this stage, my lord.
you should have said that in the beginning. We are already hearing you.
But,
now.
my lord, yes, I don't think that will be required. I apologize, my lord. Because since they are not mentioned in the list of heirs. And
Alright.
as per this Suraj Lamp judgment, my lord, Suraj Lamp and Industries Private Limited versus State of Haryana, 2012, Volume 1.
Yes.
Paragraph number 18, page 665, my lord.
Yes.
It is thus clear that a transfer of an immovable property by way of sale can only be by a deed of conveyance, sale deed. In the absence of a deed of conveyance, duly stamped and registered as required by law, no right, title, or interest in an immovable property can be transferred. So, if I may take your lordship to page 16 of the appeal.
Six zero.
16, my lord.
Sale deed.
This is a sale deed executed between the deceased and Tilal Biak Chuanga. At page 17, paragraph number 3, the consideration was rupees 26 lakhs, my lord. And it was executed between two individuals, Tilal Biak Chuanga and Dalma Chuana. There is no mention of the father, there is no mention of the H. Zaldira or the sister. They stated they have contributed. And they have accepted this sale deed, my lord. And one more thing to show. Page 22, my lord. Page 22 is my bank account of the deceased. At page 23, at the top, on 27/1/23, 21 lakhs has been transferred to Mr. Lalbiak Chuanga. And at page 24,
Page 23, on date 27/1.
27/1,
Now,
23.
how much has been transferred?
21 lakhs, my lord.
Okay. Then,
And page 24.
This is your account?
Yes, this is my account. It used to be our joint account, my lord.
joint
It used
account.
to be our joint account, yes. 27 January 2020.
Where is it written joint account?
No, my lord, after his death, it was made as my my account. So when I get the bank details,
While your husband was alive, you were not a party to that account?
no, while I was alive, this used to be our joint account. But after his death, it is conferred as my sole.
So come to page 22. Where does it say that it's
No,
both?
page 22 is the account of the deceased. Page 24 is another bank account, my lord.
Oh, no, the same account.
Not the same account.
Both are SBI, but
Both are SBI.
the account number is 1577. And this account number is, okay, different.
Different.
So this,
So we've paid in from two bank accounts.
so this page 24 is a joint account.
Used to be a joint account, yes, my lord. Here, on 27 January 2023, 1, 2, 3, 4.
How much?
5 lakhs 23 rupees. 23 rupees is for the purpose of the RTGS transfer. So in total, Mr. Tilal Biak Chuanga, who is the owner of the LSC, was paid rupees 21 lakhs.
Not 21 lakhs, 26 lakhs.
Oh, 26 lakhs. I apologize, man. 26. First 21 and after that 5 lakhs. So
So they have no share.
they have no share, man.
It's solely the
Yes.
the hard-earned money of the husband of the appellant
Yes, my lord.
and the money from their joint account.
Yes, my lord. And now, after his death, they entered the house forcefully, chased us out. Now they continue to live in it. We filed an eviction suit, but the eviction suit will be kept in abeyance until this heirship certificate has been settled. And in terms of Section 31, class of heirs has been clearly defined. And
So that is your case.
yes, my lord, they cannot make a claim, my lord. They cannot have locus standi.
right. Okay, let me hear the other side.
Yes, my lord.
Yes, Mr. Rimrod.
May it please your lordship. Firstly, I would like to mention that the property is a family property. The respondents had a ancestral property somewhere in the village of sorry, sir. In the village, and I sold it as per the request of my son, the deceased Lal Machona. And I came to Aizawl and I settled in a rented house at Electric Van. And after he retired, after the retirement of my son also, he joined me. So we all lived together in the rented house at Electric Van. From then on, we purchased a house building, a small house at Zuang Tui. But since the house was small for all of us, and it had to be, extension, to make an extension vertically. So in order to look after all the workers easily from that place itself, Zuang Tui, the petitioner, the appellant and my son, they moved to Zuang Tui just to look after the workers. Because we find it difficult from Electric Van to look after all the way from Electric Van to Zuang Tui. So while they were there, he suddenly fell ill and died. And he was not in Dang. This is, it can be, Your Lordship, it can be pointed out from the death certificate in page number 26. At the death certificate also, the residence of the deceased is clearly mentioned as Electric Van. Even the cremation was done at Electric Van in our house, in a rented house at Electric Van. So after we finished the extension of the building, only after that we moved to Zuang Tui by 30th November 2023. And after 11 days, she filed an application for heirship certificate. After 11 days of moving to Zuang Tui, then she filed an application. She filed the application of heirship certificate while we are all staying together without informing us. And she published in the newspaper, Vang Lai, that we don't subscribe.
Okay.
And since we also contribute some amount of money for the purchase and for the repair and for the vertical extension of the house, and Your Lordship, we pray this court to give us a chance to face a fair trial at the court of senior civil judge.
You have seen the bank account? Bank account.
Yes, Your Lordship.
Bank account statement shows that sum of rupees 21 lakhs was deducted from the account of the deceased in favor of the landowner, previous landowner. Subsequently, from the joint account, around 5 lakhs was deducted again.
Yes, Your Lordship.
That was a joint account, but subsequently, according to the appellant, after the husband died, she became the sole. Of course, that person cannot have an account. It became her account. So the sale deed also says 26 lakhs. So the price of the land was paid by the deceased person and the present appellant. How do you say that this is an ancestral property?
We also contributed because we,
How?
by giving cash to the deceased, by giving a cash to the deceased, and we also contributed to the extension of the vertical extension of that
Of course,
building.
extension, construction, maybe that's a different thing. But for the purchase of the plot of land, it has gone from the account of the appellant and the
Your
deceased
Lordship,
person.
that also can be assessed through evidence.
So what do you say about section 31? Subsection 1 and subsection 2. How do you fit in?
Your Lordship, Section 31(1) says, if the children have become majors, now they are minors,
They are minors, so she is the guardian. So the property should go to that minor, should go to the sons. But since they are minors, the mother will look after the property. Where does it say that father should be, it should go to the father and to the sister?
because we are living together in the same house, and he is the only son that I have to trust. And whatever he says, as the oldest son, whatever he says becomes a law in our family.
Nay, see, living together is no problem. You live together, okay. But now if the property was owned by your late son, and after he expires, this will have to go to the sons. And if the sons are minors, the mother will be the
No,
guardian.
Your Lordship, we don't argue that. You don't argue because we want to stay at that house.
Provided you are allowed to stay. You may want to stay, but if you're not allowed to stay, then what to do?
We also contributed. The contribution that we made can be adduced, can be, made out.
So what sort of contribution did you do?
No, all the other family members also work. Some are working as a teacher, some are working.
Is there any material here on the file which shows that you have contributed for the house?
Not yet, Your Lordship.
Then?
Because
So on what basis review was allowed then?
Because the review was allowed that the petitioner did not, the petitioner did not follow all the instructions of the senior civil judge on the first order.
But what prejudice does it cause to you? She may not have followed all the instructions,
Yes,
but what prejudice does it cause to you
because we did not.
when you are not in the line of the heir of that property? If you were in the line of the heir, then okay, something wrong, we have to be heard. But if you're not there as per section 31, then what difficulty can be
As per
expressed by
section
you?
31, number 3 also, if any of the son of the head of the family dies before the head of the family, then on the death of the head of the family, the head of the family's property will be divided among the surviving sons of the head of family who are not indang.
Yes, anything else?
And Your Lordship, in the Gore I Corazol Bench order in case number RFA number 18 of 2024, at para number 8 also, it states that despite knowing the whereabouts of the applicant number 1 and 2 implies that he somehow tried to keep the applicants unaware of the pending probate case. This is a probate case, Your Lordship. There was no requirement for issuing a newspaper publication when notices could have been served by way of dusty service. The 4 applicants and the respondents are all siblings of Tan Tluong, and as the issue pertains to inheritance of property of the late Tan Tluong, it was an incumbent on the part of the respondent to have informed the court that the applicants 1 and 2 are living on the top floor of the same house where the respondent was residing. Since we are all staying together, they could have served or they could have informed us that the appellant was applying for heirship certificate.
Okay. All right. We'll pass necessary orders then.
Yes, my lord. Just one, my lord. Page 55 of the appeal shows the list of the family of the deceased.
Page,
55, my lord.
what is that?
This is the family details of the deceased, my lord. It only includes his two minor son and his wife. So there cannot be a claim that he was not establishing a separate house at the time of his death. This is the service book, my lord.
Service book.
It depends, there is in relation to his
They are
service.
not even
That is in
dependents
relation to his
of
service.
the deceased.
Your Lordship.
This is the service book, my lord.
Service book. His family is there. Why should they include everyone? Father, grandfather, auntie, even?
My lord,
Not required.
if he was not establishing a separate household, then they, in respect of medical claim, everything, they would get the benefit.
All right. All
So
right.
since he has not included them.
See, I've heard both of you, so I'm passing the order.
Yes, my lord.
Heard Mr. Zoram Chana, learned counsel for the appellant, and Mr. Lalremruata, learned counsel for the respondent. Stop by filing this appeal. Under section 17, bracket 2, bracket small b of the Mizoram Civil Codes Act, read with section 96, 104 and order 43 of the Code of Civil Procedure, comma 1908 bracket CPC. The appellant has challenged the appellant prays for setting aside the order dated 22/10/2024 passed by the Civil Judge, Senior Division, Roman 5, Aizol, in review number 6 of 2024, arising out of heirship number 1428 of 2023. Full stop, next para. Facts of the case in brief is that after the expiry of the husband of the appellant on when did he die? Somebody showed me the death certificate. Where is that?
My lord, he died on 39/20/23.
30.
30.
39/2023. The appellant applied for heirship certificate for the landed property covered by LSC number CAD-2912 of 2022, located at Zhuangtui, Vengthar, Aizol. Stop. As directed by the court, the appellant made newspaper publication in Vanglaini Daily and since there was no objection from anybody, comma, heirship certificate in respect of the said property was issued to the appellant on 17/1/2024. Full stop. However, the respondents, who are the father-in-law and the sister-in-law respectively of the appellant, filed review petition number 6 of 2024 before the Court of Civil Judge, which issued the heirship certificate, claiming that they had not been informed about the application for heirship certificate for the property in question, and that they have a right to the said property to stop the learned civil judge, therefore, by the impugn order dated 22/10/2024, recall the heirship certificate issued to the appellant. And restored the heirship certificate case number 1428 of 2023 for fresh consideration. With the participation of the respondents. Stop aggrieved, the petitioner, the appellant is before this court in appeal. Next para. Mr. Zoram Chana, learned counsel, submits that as per section 31 of the Mizo Marriage, Divorce and Inheritance of Property Act, 2014. Bracket, Inheritance Act, close bracket. The property left by the deceased father is to be inherited by the sons who are not indang, and the surviving wife of the head of the family equally. Full stop. On the death of the head of the family, the wife automatically becomes the head of the family, and if she remains a chaste widow, no, and you cancel and, okay, not required. head of the family if she remains a chaste widow and looks after the welfare of her minor children. Full stop. He submits that out of her wedlock with the deceased, a son and a daughter, two sons were born to them, who both are minors. Stop. Therefore, the appellant as a guardian of the minor sons, as the legal guardian to the minor sons, is entitled to look after the property left behind by her late husband. Full stop. He submits that the respondents, on the other hand, do not belong to any class of heirs as provided under Chapter Roman 8 of the Inheritance Act, and they cannot have any claim to the property in question. Full stop. Next para. The learned counsel further submits that the property in question was bought by her late husband during his lifetime by executing a sale deed on 30/1/2023. Stop. Referring to the bank account of the late husband of the appellant under account number 30023776915 bracket SBI, the learned counsel submits that a sum of rupees 21 lakhs was withdrawn, was debited to the, was credited to the account of Sri Lal Biak, what's his name? Chuama. Lal Biak Chuanga, the previous owner of the property in question, on 27/1/2023. Stop. Thereafter, from the joint bank account of the appellant and her late husband under account number 6 zeros, okay, 006, then 10665651 comma, a sum of rupees 5,00,023.60 was credited again to Sri Lal Biak Chuanga on 27/1/2023. Is the date similar?
Yes, my lord.
Okay. On the same date, that is 27/1/2023. Stop. He also submits that the sum of rupees 23.60, what is this?
Towards RTGS charge, my lord.
Is only towards RTG charges. RTGS charges. Stop. The learned counsel submits that as per the sale deed, the land in question was bought by her late husband for a sum of rupees 26 lakhs. Stop. He therefore submits that it is clear that it was solely her late husband who had purchased the land in question, and therefore the respondents cannot have any claim to the said property in question. Next para, the learned counsel further submits that while allowing the review petition filed by the respondents, the learned court below came to the conclusion that the respondents have a locus standi to file the review petition, and for that reason the review petition was entertained and allowed. The learned counsel submits that since the respondents do not belong to any class of heirs as per section 31 of the Inheritance Act, the said finding of the learned court below would amount to amending the Inheritance Act itself, and therefore the impugn order should be set aside. To stop, next para, the learned counsel also submits that although the appellant was directed to make newspaper application in the local newspaper at Zhuang Tui, but during the relevant time there was no local newspaper available in Zhuang Tui locality, and for which reason the appellant could not make such publication. To stop, he submits that in fact a certificate to that effect has also been issued by the local council member, chairman local council Zhuang Tui. To stop, he thus submits that the impugned review petition should be set aside and the appellant be allowed to enjoy and the appellant allowed to enjoy the property in question by reviving the heirship certificate. Stop, next para. Mr. Lalram Rota, learned counsel for the respondent, on the other hand, submits that the respondent number 1 moved to Aizawl from their hometown, from their village, after disposing of their ancestral home by staying in a rented house in Electric Way. Stop, the appellant, no, the late husband of the appellant, who is the son of the respondent number 1, also was staying in the same house with his family. Stop. Eventually, a plot of land was purchased. No, you cancel that. Eventually, the property in question, the property in dispute, was purchased and for which the respondents had also made contribution. Stop. Since they were all staying in a rented house, a small house was being constructed in the said property. Stop. Due to the difficulty in looking after the construction of the house in the said property, his son and his family moved to the said property. And for construction of the house there, the respondents had also contributed, had also made their contribution. To stop. Eventually, the respondents moved to Zhuangtui in the constructed house, and within a few days, the appellant applied for heirship certificate without informing the respondents. Stop. He submits that at Zhuangtui, they did not subscribe to Wanglani daily, and therefore there was no possibility for the respondents to know about the application for heirship certificate submitted by the appellant. Stop. Soon after coming to learn about the issuance of the heirship certificate to the appellant, they applied for a review, and accordingly the same was allowed. Stop. The Learned Counsel also submits that since the Learned Court below is yet to decide as to whom the heirship certificate is to be issued, the respondents therefore should be allowed to contest the heirship certificate application, wherein the appellant also will be having equal opportunity to make her claim for the property. Stop. He therefore submits that the impugned order may not be interfered with by this court. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Full stop. Facts as narrated by the appellant is not being repeated for the sake of brevity. Stop. The documents enclosed by the appellant in the present appeal, which also appears to be a part of the annexures to the heirship certificate application, includes the sale deed by which the property in question was bought from one Sri Tilalbiak Chuanga for a sum of rupees 26 lakhs. Stop further. The statements, the bank account statements of the bank account statements annexed by the appellant also goes to show that the amount spent for purchasing the land in question was debited from the joint account of the appellant and her late husband, and also from the account of the late husband of the appellant. Stop. Although newspaper publication was said to have been done in the local paper, that is Phanglaini Daily, but according to the respondents, they were not aware about the same. Stop. The learned counsel for the appellant has also tried to impress upon the court that Section 31 of the Inheritance Act does not give any right to the father of the deceased person or to his sisters the right to claim the property left behind. Stop. However, from the stand taken by the respondents, they claim that they had paid certain contribution for purchase of the said property, and that it was not solely the appellant and her late husband who had bought the said property. Stop. Besides the property in question, it is also contended by the parties that a house has been constructed in the said property.
The house was already in existence, my lord, at the time when we purchased the LSC.
The house already in existence had been renovated
Vertical extension was done.
An extension was done to the same. Full stop. Stop. Therefore, having regard to the respective claim made by the parties, this court is of the considered view that the parties concerned should make their respective claims before the learned court below. Stop. Accordingly, this court does not find any reason to interfere with the no, that you cancel. You cancel that paragraph, that sentence. One aspect of the matter which has drawn the attention of this court is that the learned court below had made an observation or a finding that the respondents have a locus standi to file the review petition. Full stop. The same, however, no. Cancel that sentence again. Accordingly, the matter is remanded back. No, right like this. Accordingly, this court does not find any reason to interfere with the impugn order dated 22/10/2024. Since liberty has been given to the parties to contest the case on merit. To stop, it is however made clear that the observation of the court below that the respondents have the locus standi to file the petition would be confined to the filing of the review petition, and the fact as to whether they indeed have a locus standi to claim for the property in question will have to be decided in accordance with law, importantly in accordance with the Inheritance Act. Next para. This court is informed that there is an eviction suit filed by the appellant which has been suspended on account of the pendency of the heirship certificate application case. Stop. Therefore, the learned court below shall make an endeavor to consider and dispose of the heirship certificate application as expeditiously as possible, and preferably within a period of 3 months. From the date of appearance of the parties. Stop. Since both the parties are represented before this court, they shall appear before the court below on any date you want to suggest?
Next week, my lord. March 25th, my lord.
Mr. Remrota, 25th, Tuesday.
Yes, my lord.
On 25th of March 2020, 5. Whereafter, the learned trial court shall proceed with the matter in accordance with law and come to and bring the case and bring the certificate case to its logical conclusion by giving due opportunities to the parties. With the above observations and direction, the appeal stands disposed of.
Obliged, my lord.
Thank you and oblige.
Item 2.
Both of you, one of you go.
May it please your lordship, I'm appearing
Just
on...
a minute. One of you stay back. Who will write order? One of you stay back. One of you go. Yes.
May it please your lordship, I'm appearing on behalf of respondent number 1 to 3, your lordship. I've received the pairwise comments. If 2 weeks time may be granted to file the affidavit in possession, your lordship.
Who's for the petitioner?
Mr. J.C. Lansang, I think he's on...
Yes.
Actually, this is your auntie. I heard that. I don't know whether
Sorry?
you take it up or not.
They want some time. They want to file counter affidavit. We'll grant them some more time. As paid for by.
No, what I said is that this my client is your.
I can't hear you.
My lord, actually, what I said is that my client is your auntie. Whether you're inclined to take it up or not. That's what I said.
Anyone can make out?
No, your lordship.
Your voice is breaking, that's why.
My
Yes.
lord,
Mr. Roku, just a minute, Mr. Roku is here.
My lord, what my senior is trying to say is that the petitioner is the auntie of your lordship, has a familial tie. So, for that reason, the matter may be recused. If
my lord, am I audible now?
Yes, you're audible. Sometimes and sometimes not. How do you say that? Are you sure?
Yes, PBF Kumi. I don't know. I heard.
I cannot take up this matter. Or what?
If you want, you can take it up. But since your auntie, I heard that. This is Patin.
But the address here is Tuikotlang.
Earlier in the this thing, the earlier address.
And our father is Thanga. My grandfather is not Thanga. Anyway, if you say so, I don't know, you must be knowing better. Okay. What is the matter regarding?
Hello, there is cancellation of my LSC.
Huh?
Cancellation of my LSC.
Cancellation of LSC. Where?
Yes.
Where is the LSC?
And then by order, you see the petition. The last listen, it starts from page number 139. Without giving any notice.
Okay.
So actually, if they're filing counter, it's fine, Your Lordship, because they have been delaying almost 1 year.
So, since you have enlightened me, I cannot pass any order also. So, list this matter before any other bench
That was actually, I am not so sure, so I think.
and not before me. Bracket my name. Okay, it'll come up before any other bench.
Yes, Lordship. Much obliged.
So, I'll just take 5 minutes break and come back.
We see your
Item
lordship's
3.
indulgence, your lordship. Joint prayer from both parties. Item 3 of part 2. It's supposed to be taken up today. But if your lordship will kindly fix it in the coming week, if possible on Thursday. (27th).
Item 3.
Yes.
Okay, as on the joint prayer made by the parties, list this matter for hearing on 27th of March 2025.
Be obliged.
Item 3.
My lord,
Yes,
regarding part 2, item number 13, yes, if it is possible to have after a week, and in the meantime, we are attempting to resolve the matter between the parties.
is it so?
So,
1 week?
Yes.
yes.
Okay, list the matter again after a week. As the parties are said to be making an attempt to make an out-of-court settlement. Yes.
Highly obliged.
Yes.
Regarding item 3, Lordship, pleadings are complete now. In the meantime, Lordship, my learned friend has supplied me one document saying that there is some judgment passed by coordinate branch of this court which may cover. So for that, my lord, if this matter may kindly be taken up after a week, my lord. In the meantime, I'll look into that document.
What is the issue regarding?
This is regarding non-payment of compensation to the petitioner who is landowner within Sermun village, Lordship, due to the Dampa sanctuary extension, Lordship.
I see. What is the scheme of that sanctuary?
Actually-
Some amount is to be given.
Yes, 10 lakh each to
10 lakhs.
all the residents, yes.
You have not
But
been given.
No, not number one. Number two, I'm having LSC, my lord, within the land. And those to whom 10 lakhs has been given are only residents without any land pass, Lord. So my case is quite different.
Okay. So you're saying that there's some other case which covers your case also, or what?
That,
Yes, Your Lordship. As per submission that has been made in the affidavit in opposition, this matter was actually, it is seen that this petition, the area concerned actually falls within the same preliminary notification which was executed by the state. So, Your Lordship, and accordingly, the 10 lakhs was actually given as per the National Rehabilitation and Resettlement Policy 2007. So, a similar case was filed in 2021 regarding the Dampa relocation. In that case, Your Lordship, as per the said National Rehabilitation and Resettlement Policy 2007, there is a ombudsman to be appointed. So, Your Lordship, it is seen that alternative remedy is available at this stage to look into the representation, Your Lordship.
There's a case like that.
Yes, Your Lordship.
Decided? What
It has
is
been decided in 2022, Your Lordship.
Decided in 2022.
Yes, Your Lordship.
Then what has happened to that case then?
Your Lordship, accordingly, an ombudsman has actually been appointed as well, Your Lordship, in 2024 itself. And he's actually looking into the matter in the previous 2021 case, Your Lordship. And similarly, in this case also, the petition...
Any conclusion yet?
No, Your Lordship, it has just been, at this stage, Your Lordship,
You produced that notification appointing ombudsman, and what is the process?
yes, Your Lordship, if I may produce the 2007 policy and also along with the judgment of 2022.
Is it not a part of your counter affidavit?
Your Lordship, it is not, Your Lordship, because the vetted version does not have these submissions, Your Lordship.
Then how did you get that copy?
Because, Your Lordship, I got it because it was actually said to be a covered case I saw the previous Irene Zosang Rani case. So it is similar in fact, Your Lordship.
Anyway, you share that thing with Mr.
My
Zoran.
I've shared it, yes, Your Lordship.
We'll see. Okay. Parties are represented by the respective councils, and they submit that the matter may be taken up for admission hearing after a week.
Can I have a fixed date, Lordship?
When do you want it?
On
Yes, paid for list the matter on
28, Lordship.
Friday.
Thursday. 27, Lordship. Thursday. Or will it be difficult?
It will not be difficult. There's one case which Mr. Malhotra
Mine.
and Mr. The entry had just fixed.
Mine.
List the matter on 27th of
For admission,
March
ma'am.
2024. For admission. Yes.
Obliged.
Item 4.
I seek your lordship, I may be given further time for, because the petitioner number 1 is a member of the KMMTP Road
Yes.
Landowners Association.
That case.
Yeah,
What has
case.
happened?
Yeah. Now I have submitted my application to delete my name from the association. However, in the meantime, the office bearer of association is dissolved, so newly appointed office bearer will be formed.
How much
So
time?
I may be given after holiday, lordship.
That's paid for by Mr. Dinariti Azul, learned counsel for the petitioner. Petitioners. List the matter again after the ensuing. What is this vacation? Summer?
Yes,
What vacation is this?
summer. April.
Last week of April?
Yes,
List the matter on the last week of April 2025.
August.
Item 5.
My lord, the petitioner would not like to pursue the matter further, so I would
You'll
like to
withdraw.
withdraw this petition, my lord.
Okay, Mr. Silal Faxwala, learned counsel for the petitioner, submits that he has instructions to withdraw the writ petition, since the petitioner would not like to pursue the matter any further. Ms. Lalman Louis, learned government advocate, appearing for the state respondents, have no objection to the prayer. In view of above, the writ petition stands disposed of as withdrawn.
Much
Obliged.
obliged, Your Lordship.
Item 6.
Then IA also is there, na? Pending? All disposed, okay.
May it please Your Lordship, I'm appearing on behalf of respondent number 1 to 9. I have sought the pairwise comment, and the pairwise comment has not been received, Your Lordship. So if
How much time?
3 weeks' time may be granted, Your Lordship.
My lord,
Yes.
my lord, if your lordship would kindly come to page number 101. My lord, this is a covered case. Similar case with this WPC number 124 to, oblique 2023. Your lordship has passed this order on 11/6/2024. And my lord, the instant petitioners herein are also landholders. However, the only difference is that the petitioners in WPC number 124, oblique 2023, are LSC holders, whereas the instant petitioners herein are periodic pata holders, my lord.
What is the case about?
My lord, the lands have been utilized for construction of PMGSY road between Luangmol to Vaisam in Lunglei district, my lord.
And so?
And that construction had affected our lands, my lord. The road has gone through our lands, passed through our lands. And your lordship, by this order, this is at page number 107, paragraph 9. Your lordship has directed the respondent authorities to conduct verification, spot verification, headed by the Deputy Commissioner, the Director of Land Revenue Settlement, and the CEO Mirda, along with the landowners, madam. So my prayers, my lord, is that,
See, at page 103,
My lord.
paragraph 3,
my lord,
it appears that some verification was already done.
yes.
So, if verification was already done, why was the requirement to have another verification?
My lord, because in we have heard that the joint verification team set up by this honorable court in this order had conducted a spot verification over these lands. However, in that, my lord, the lands of the instant petitioners were not included,
Why should it be included?
my lord.
There were no other petitions in that
Yes,
case.
my lord.
They could have done that if they're on their own, but since it was not a part of the order,
Yes.
though. Now, what happened to that verification?
My lord, so far as my knowledge is concerned, beside that, they have already conducted the spot verification, my lord. I cannot inform this court of the development, my lord.
What is the sum and substance of that case, Mr.
My lord,
Zekima? See, there was verification already done, and something was referred here regarding some RFA was referred here, isn't it?
my lord.
Damage suit. They had filed civil suit, damage suit, I think. Then state filed an appeal. Then the appeal was dismissed by this court. In your case, you have not filed any civil suit.
No, my lord.
Have you seen this judgment, Ms. Lalunhui? Will it be applicable to their case?
Your Lordship, I have not actually gone into the details of the case, and I will have to confirm and seek instructions, if at all, because if they're not part of the, if they were not even a party to the case, would it be?
No, they were not a party to the case, that is for sure. But they say that they are similarly situated and the construction of the road is same. That is, what do you call? What is the stretch of this road?
My lord.
Lunglon to Vaisam,
Yes.
correct?
Yes, my lord. Lunglon to Vaisam.
And they were LSC holders, you are periodic pata holders?
Yes, my lord. The instant petitioners are periodic pata holders.
See, this is under the PMGSY.
My lord.
Similar situation everywhere. In Arunachal also there were many cases wherein lands have been, roads have been constructed through private lands under the PMGSY scheme and no compensation. The authorities say that there is no component for compensation, we cannot pay you. But to implement the scheme, They have to show that there is land available.
Yes, my lord.
And that land available is a private land. So without taking consent of that landowners, they show land, this is the land available, scheme gets implemented, the fund comes, and they start digging, but no compensation is given to them. And they come to the court like this, same thing. But here I think this court has directed that it cannot be accepted. And one instance was taken wherein one party filed damage suit. Civil court awarded compensation. State filed appeal was dismissed. So, anyway, let her go through it and get instructions.
My
We'll
lord.
give her one more chance.
My lord.
All right. Mr. Tilal Zakima, learned counsel for the petitioners, by drawing attention of this court to the order dated 11/6/2024, passed by this court in WPC number 124 of 2023, bracket Annexure 21, submits that the present petitioners are similarly situated and therefore a similar direction may be issued. Full stop. He submits that the only difference is that the petitioners in WPC number 124 of 2023 are LSC holders, whereas the present petitioners are having periodic patta. To stop, he submits that the construction of road from Lunglon to Vice Sam under the PMGSY scheme has affected their land, and therefore the instant writ petition is filed for claiming compensation. Next para, Ms. London Louis, London Government Advocate, submits that she is yet to receive instructions in the matter, and therefore prays that she may be granted further 3 weeks' time to file counter affidavit. Full stop. She also submits that she will examine the order dated 11/6/2024, passed in WPC number 124 of 2023, and seek appropriate instructions. Full stop. In view of above, matter stands adjourned for 3 weeks.
Much obliged, Your Lordship.
Item 7.
Your Lordship, as per the last court's order, the respondents were to obtain instructions for filing
What
counter
instructions?
affidavit. For filing counter affidavit, Your Lordship.
What is this matter regarding?
Lordship, this matter is the encroachment of the petitioner's land in the process of construction of NHIDCL. I mean, in the construction of National Highway 6, that is from Dulte to Champai, Your Lordship.
From
From
Dulte
Dulte
to
to
Champai.
Champai.
NH6.
Yes, Your Lordship.
How many petitioners are here?
2, Your Lordship.
2 petitioners. Your land has been affected.
Yes, Your Lordship.
So, last time who appeared for NHIDCL? Where is Mr. Samuel?
Mr. Samuel is out of station, and however, he have not received any instructions with regard to the agreement submitted by the learned counsel for the petition in last court date.
What is that agreement? You are aware about the agreement?
Your Lordship, at this point
What-
of time, I don't have the agreement.
What sort of agreement was that?
Lordship, as per my knowledge, Lordship, it was about giving the compensation for the land that has been affected.
Who will give compensation?
Lordship, the agreement was between Kala and NHIDCL and the petitioner.
No, that's correct.
Yes, Your Lordship.
Kala cannot give money.
Yes, Your Lordship.
Only when money is deposited, he'll disburse. So petitioner cannot give money to himself, so obviously not the petitioner. Then it must be NHRDCL.
Next week. Yes, my lord.
Let him get instructions. Where was the order dated 31/1/2025, wherein Mr. Samuel Vamshi Sangte, Learned Counsel, appearing for the NHRDCL, was required to obtain some instructions regarding the so-called agreement reached between the Kala petitioners and the NHRDCL. Stop. Ms. Caroline K. Lungoipi, Learned Government Advocate, submits that Mr. Samuel Vamshi Sangte is out of station, and he has also submitted leave of absence. Stop. She submits that he is scheduled to be in station within a week. In view of above, list this matter again after a week.
Yes, my lord.
Obliged, Your Lordship.
Obliged.
Item 8.
Item 8.
My lord.
8.
8.
This is your case.
Yes, my lord. It pertains to challenging the impugn order of the single bench, my lord, in RFA number 2 of 2022, my lord.
Can you do that?
We are proposing the substantial question of law, my lord.
No, that is okay. RSA is basically maintainable only when there is substantial question of law involved. But here is a case wherein you are challenging the order passed in the RFA.
Yes, my lord.
And the order passed in RFA is by a single bench of this court. So you are challenging the single bench decision before another single bench. Is it possible?
My lord, in that regard, yes, the registry had put up the matter before the single bench. That is also what I am not understanding. So, my lord, to my humble opinion, my lord,
Yes, tell me.
if the matter is admissible, it may be referred to the division bench, my lord, by framing a substantial question of law, my lord, under this second appeal, my lord.
Under what provision?
Under this
You show me the provision, we'll refer it just now.
section, I'm referring to the section 100, my lord, section 100 of the CPC.
Okay, let us read section 100. You have a copy?
Yes, my lord, I have the copy.
Please read.
Safe as other, if I may
Read.
my lord. Safe as otherwise expressly provided in the body of this court or by any other law for the time being in force, an appeal shall lie to the High Court from every degree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law.
Just stop there.
Here it seems that the degree
From every degree passed in appeal by any court subordinate to the High Court. So that
Well,
single bench who passed that order in
Yes,
RFA is subordinate to this court.
No.
Then?
It's, yeah.
How can you file such an appeal, Mr. I don't know. So what else is there? The rest is, of course, regarding substantial question of law, that okay, that is a normal routine. But the forum where you should go is not before the same court. That court and this court is same. Single bench, single bench.
Yes.
And there is no issue regarding second appeal being heard by division bench. Second appeal is heard by single bench of this court, always. And what it hears is the judgment and order or decree passed by the lower appellate court. Court of district judge, court of additional district judge, hearing the case in appeal, that is RFA. Any decision passed can come before the High Court as RSA. But if that RFA is entertained by the High Court, a single bench of this court, and decision is taken, you have to go there in Delhi, not Nizam or Guwahati.
My lord, my lord,
You have to go to Delhi, Supreme Court.
my lord. I may be allowed to.
So withdraw.
Yeah, my lord, my lord.
I hope it's clear to you, because
I
there should
know,
not be
I
any
understand,
doubt.
my lord.
There should not be any doubt.
I understand, my lord.
Appeal, as per the Mizoram Civil Codes Act also, same thing. CPC, same thing. So it says that,
In that regard, my lord, I hope your lordship will also understand that under section 17, if the valuation of the suit is more than rupees 10 lakhs, the first appeal has to be referred to the High Court. So that's why the present appeal is also decided by the single bench.
no. Of course, the first appeal is decided by a single bench. Had it been decided by a subordinate court like district court, district judge, or a additional district judge, definitely second appeal will lie before this court.
My lord, my lord.
But once the single judge of this court, in view of the evaluation perhaps, has decided, then there is no further remedy except to go to the higher forum.
My lord.
Do you want a copy of the, do you want to withdraw a copy of your certified copy? I'll permit you
If
that.
I am allowed, yes, my
I'll
lord.
permit you that. The rest will remain.
My lord,
The original certified copy, you can have it back.
my lord.
Okay. As paid for by Mr. F. Lal Yangliana, learned counsel for the appellant, the appeal stands dismissed as withdrawn. Stop. The appellant is, however, given liberty to approach the appropriate forum. Stop. The appellant is also allowed to withdraw the original certified copy of the impugned judgment and order sought to be challenged. Yes.
Obliged, my lord.
Part 1, hearing item 10.
Who is for the other side?
My lord, Mr. Johnny, he's coming, my lord. His junior is calling him.
Mr. Johnny. Okay.
Yes.
Where were we yesterday?
So, my lord, yesterday, as far as my understanding is concerned, my lord, we had appreciated the evidence of the appellant. Let me only, my lord, summarize my submission yesterday, my lord.
Yes, please do that. Please recapitulate it.
So yesterday, lordship, basically, the issue, lordship, remember the facts. The facts are basic.
Dika, both of you may go. This will take some time.
My lord,
Yes.
I don't think I have to mention the facts and all, but basically, my lord, the basic claim, my lord, is that we are both the wives. Basically, that's the claim. They are claiming that they are the wife, and we are also claiming that I am the wife.
You're the first wife, she's the
first
second wife.
The second wife. Our basic submission is, my lord, that there is presumption in our favor that I am the wife, as well as certain evidence that strengthens that presumption. And some of these documents, my lord, includes Section 125 order, which was passed by the CJM. That was the first. And the second is, lordship will remember Form 7.
CS Form 7.
CS Form 7, wherein I was specifically mentioned as the wife. And the third is the will, the probated will.
And the fourth is the legal notice replies, Exhibit D5, at page 55, my lord, of the paper book.
What is that, D5?
My lord, exhibit, I'll take your lordship to exhibit P5.
This is an RTI reply.
RTI replies, my lord, at page 55.
Where is that, section 125?
Section 125, my lord, is at page 57 of the paper book.
D6,
Yes,
exhibit D6.
D6. And
Okay,
fourth,
let me just say.
Yes.
One is 125 CRPC, one is Form 7,
Yes.
the other one is the will,
correct,
and the other one again is the RTI reply.
correct, my lord.
RTI reply was regarding,
Four questions were asked, my lord, at page 54.
54
Yes,
or 56. 56
Yes.
is the answer.
correct. 56 are the answers. This is exhibit D5. So the first is the answer. The late Sri Thang Yinglova did not make any application to marry Srimati Vanalpari. Srimati Vanalpari is the respondent. So far as knowledge of this department is concerned, the department is unaware of his divorce of his first wife through a court of decree. Yes, he maintained her. He maintained her means the first wife, and copy of court order is enclosed herewith. And fourth is documents submitted by Srimati Vanalpari to this department are enclosed herewith. Now,
Okay, 1 minute. This regarding a government servant cannot have more than one wife, legally wedded wife.
Yes,
He is a part of the CCS conduct rules.
CCS conduct rules.
Okay.
Rule number 21.
So when the wife is
Still
present,
live. Yes,
when the first wife is living and present,
Yes.
and there's no divorce,
there's no divorce. He has to take.
how will he apply for application before the department? Give me permission to marry a second wife.
But that is.
Knowingly you have asked this question to serve your purpose.
Exactly, my lord, because we knew Rule 21.
You knew the answer, but you still asked the question.
Ask the question. We wanted to see, my lord, because, yes,
Did he apply, did he make any application to marry so-and-so?
yes.
Okay. Then,
Then the second is, my lord, the department is unaware of his divorce with his first wife through a court of decree. Third is, yes, he maintained her and a copy of court order is enclosed herewith. Fourth is documents submitted by Srimati Vanalpari to this department are enclosed herewith. Now, documents submitted, my lord, are is the
who's
legal
Vanalpari? You are Vanalpari, no?
Vanalpari is the respondent.
Okay,
my lord.
respondent.
And the documents submitted, my lord, is the legal notice, which is at page number 60.
60.
Yes.
This is demanding the pension.
Demanding pension as well as the other service benefits.
Page 60?
Yes, page 60. And the reason why we are using this
No, what is page 60 is somewhere in the middle only.
it starts, it's the legal notice beginning, my lord. And it goes on till page number 62.
No, how come? Okay. Okay, 60 of the paper book, isn't it?
Correct, 60 of the paper book.
I'm looking at the other memo. 60. What is the demand?
The demand, my lord, is at page number 62. 9, paragraph number 9, that my client husband had nominated his wife, Srimati Vanalpari, to draw his GPF, GIS, etc. in his service nomination. That my wife had entitled to draw the service benefits of her beloved husband, Sri Thanghinglova, like GPF, GIS, leave salary, DCRG, pension, etc. Now, my lord, with regards to this nomination, she had not submitted any nomination in this legal notice. No nomination form was submitted in this legal notice. But she simply claimed that she was nominated in this legal notice.
Nomination was in fact on the
Favor
children.
of the children.
Children were nominated.
Yes.
They've already taken the
They
money
have
also.
already taken. And the wife, my client, has been named as one of the, not one of the wives, has been named as the wife in that nomination. So this legal notice, my lord, first of all, is not...
In case the nominee predecesses the nominees,
Yes,
then it'll go to the wife,
correct,
like that.
like that.
Okay.
And number 6, my lord, in number 6, paragraph number 6, in the last sentence, she had stated, my client husband had divorced wife. Now she's claiming that the appellant is a divorced wife and having 3 children from her previous marriage. Now what I am saying, my lord, here is this, that she has accepted that he was previously married to my client, to the appellant. So because of this reason, we are saying that this is also a proof that the appellant was married to the deceased person.
Okay.
And the other point, my lord, is the examination in chief, wherein we had mentioned
Where's that page number?
the examination in chief, my lord, at page number 123. We had mentioned throughout the examination in chief, my lord, that we are the wife, and in the further re-examination, my lord, at page 132,
The headship was applied for by the respondent
by the respondent.
and it was granted.
It was granted without without proper notice given to us. And because of that, it got remanded back. She applied in Lunglei, my lord.
No, headship was given to you.
No. So what happened was, my lord, when the deceased person died, things were processed in favor of me and my children initially. So she submitted a legal notice. And the legal notice, my lord, did not bear much fruit. In fact, in the meantime, we filed a writ petition in favor of the children because they are the first nominees. She did not contest, and that writ petition was given in our favor.
She was a party?
She was a party, my lord.
Okay.
She did not contest, and that was not challenged. The writ petition was not challenged. In fact, the department has disbursed all the money to the children.
Okay.
And thereafter, my lord, when we were going to file a writ petition, that's why all these RTI replies are there, my lord. Writ petition for the wife with regards to the pension, because it appeared that she was making some problem. The department was not processing it quick enough, my lord. In the meantime, what she did was, instead of filing a writ petition or other steps, my lord, she filed a heirship certificate case application. Now, when the certificate was issued to her, my lord, and she submitted the same in the department,
It was issued.
it was issued in her favor without our knowledge.
Okay.
We did not have any knowledge of this heirship. The moment we came to know the heirship certificate was there, my lord, we came to this court. And this court had passed the order in our favor, my lord. I mean, in our favor as in remanding, setting aside the heirship and the order, granting the heirship, and remanding it back to the court for adjudication, my lord, from the stage of filing written statement and counterclaim. So we filed a written statement counterclaim, and the trial took place, my lord. And this is the second round of appeal.
What did you file before this court? Appeal, RFA?
RFA, my lord,
RFA.
against that heirship.
So this, the position here is before the heirship court.
Before the heirship court. And this is the continuation of the heirship court, my lord.
And this 123 is the appellant.
123 is the appellant.
What is there to
If we go through the entirety of the in-chief, my lord, I will not read through it. But she has, time and time again, my lord, mentioned that she is the wife. And at page 132, my lord, at page 132, this further examination in chief, my lord, I will quickly read only 2 paragraphs. After
Yes. Read.
After the death of my husband, the department in which my husband had worked, namely Directorate of Agriculture, Aizawl, Mizoram, had paid me an amount of rupees 50,000 as condolence ralna. They also gave me 1 photo album. So basically, in the first thing we are saying here, stressing here is, my lord, the department itself acknowledges her as the wife. That's the first. Aizawl Klang Nuam YMA also paid me a sum of money and Holy Bible as condolence ralna. And various departments of Klang Nuam Salvation Corps also paid me several things as condolence ralna. I was also given several things as well as money by several individuals as condolence. When my husband died, I and our children, born in wedlock between me and Thang Hing Lovak, prepared the grave of my husband, and we have continued to take care of the grave. All the burial ceremony was conducted in our residence at Klang Nuam. So the entire ceremony when he died in Klang Nuam, was done at Klang Nuam. He was buried at Klang Nuam. The wife was acknowledged by everyone as as the wife of Thang Hing Lova. So this is another evidence, my lord, we are saying in chief, as long as this further examination in chief is another evidence that strengthens the presumption of marriage in our favor.
Okay. Yes, what else?
And one more thing, my lord, one point which the other side would probably stress is that the marriage certificate and the Manhlana documents are not present in the records. My lord, she was asked this question by the other side at page 133, and she had specifically stated, my lord, that the same were misplaced by her mother, my lord, at page 133.
Misplaced by?
Her mother. Paragraph number 5, my lord. It starts off in a very awkward sentence, my lord. It is a fact that I have no marriage certificate and we have no Manhlana lekha. The same were misplaced by my mother. Now, my lord, in this, first of all, the first sentence yesterday we had also discussed a little bit, my lord. It appeared that there is nothing, but what she had meant to say, my lord, from the second sentence is that these documents are not part of the record.
And number 2, DW2 is the person who had handed over the bride's price.
Correct.
And DW3 is?
The person who was not willing to accept the divorce when the Sumswana, because initially in 2009, she had intended to divorce the deceased. But then they were not willing to accept the bride price, returning of the bride price, Sumswa. And so because of that, the marriage subsisted. And eventually, before he died, they continued living together again. So for a period of around 5 years, they did not live together. In the intervening period between those 5 years, the respondent came into the picture.
Yes.
Now, my lord, with respect to the respondent, now that is with respect to the petitioner, my lord. We are saying that the presumption has been completely strengthened and that it is not rebutted, and she is definitely the wife. Now, with the respondent, my lord, our humble submission, first of all, is that her evidence of marriage has been completely rebutted by this letter dated 28/4/2016, my lord. This is Exhibit D3. Exhibit D3, which is at page number 53, my lord, of the paper book.
'53.
Yes, page number 53. The original Mizo translation was handed over to us later, my lord, because of the order of this court. But the English translation is there in the paper book. I have both the Mizo and the English translation. But let me read out the English translation, my lord.
Yes.
Page 53. I Thang Hing Lova, AAI Post Longklai, kindly request you not to give hand over my salary to anyone unless it's me or my son, Lal Thanpuya, who resides at Chon Puiveng, Aizol. I came to know that Vanlal Pari Lunglei Luangmol tried to take my salary. She also took my important document, GP Fund withdrawal application and GP Fund statement from Directorate of Agriculture, Aizol, without my approval. I beg you not to further give anything to her without my approval. Vanlal Pari and I are not married. She is not my wife, nor does she have any authorization. In the Mizo translation, it's written like this, my lord. I'll quickly read. Vanlal Pari nenhian in na kan nelova kanupui anilova authorization po engma anelo. That's how it's written in the Mizo translation. Now this was not Exhibit D3, Exhibit D12. My lord, they were not appreciated by the lower court. Exhibit D5 also was not.
What is D5?
D5 is the
The
RTI
RTI
reply.
reply.
Yes. In the judgment, I'm not sure D5 was there, but D12, my lord, and D3 are definitely not there reflected in the judgment, as far as my knowledge is concerned. Now, what the respondent had done, my lord, the respondent had relied on several documents, my lord, in order to prove her case. Now, let me just take your lordship to these documents, my lord.
I think we'll have to come back to.
Yes.
All right. We'll continue.
My Lord, with your Lordship permission, may I kindly mention item number 14 of the hearing list, my Lord? If it can be listed on Monday, my Lord, fixed on Monday.
Who's for the other side?
My Lord, I'm appearing on behalf of respondent number 5.
Hmm.
So,
So what do you say?
it's okay, I have no objection.
What is the matter?
It's a writ challenging Lok Adalat award, my Lord.
Lok Adalat.
Yes.
Okay. Monday?
Yes, my Lord, if possible.
Okay, please write. As prayed for by the learned counsel for the petitioner, not objected to by the other side. This is the matter for hearing on 24th of March 2025. Item 14, okay? Yes.
Most obliged, my Lord.
Much obliged.
Yes.
Yes. So, my Lord, I had just submitted that the presumption of marriage in favor of the respondent, my Lord, is rebutted by the letter dated 28/4/2016. My Lord, I had just read out the letter. Now, furthermore, my Lord, if I take your Lordship to the examination in chief of the respondent, it is short examination in chief, it's at page 103.
Yes.
I'll quickly read it out, my Lord. I'll read from paragraph number 2. I am the applicant of this instant application of heirship certificate number 66 of 2017, and I'm the legal wife of the deceased Thang Hinglova. That I have applied the heirship certificate of my deceased husband, and we have published at the daily newspaper of Vanglaini 2 times, that is dated 4th and 6th July 2017, and no one submitted objection in the Honorable Court within 30 days, and the Honorable Court had issued heirship certificate in my favor of heirship certificate number 66 of 2017. The said Vanglaini newspaper and heirship certificate number 66 of 2017 are exhibit in the court. That I married Thang Hinglova on 4th June 2011, and bride price was paid on, and our marriage is registered on dated 5th June 2012. That our marriage register certificate was also issued by the competent authority, and Manhlana letter was also made during that time. That the said marriage registration certificate and Manhlana are attached as an annexure in my application. That after we have married, we are living together at the same house and living as husband and wife, and all the peoples in our locality recognize us as husband and wife. That my husband Thang Hinglova was our family householders. His name was included in the family ration card, which was issued by the competent authority of DCSO Lunglei, and the said family ration card is at annexure on our plaint, and it was exhibited in this court. That our marriage was expressed and identified by the public, and I used, my Lord, this is very important, I used my husband's name on my voter's identity card, which was issued on the date of 9/3/2015. On my voter's ID, our address was mentioned as house number 12, Luang Mall, Lunglei district, and my husband, Thang Hinglova, voter's ID was clearly mentioned in his address, house number 12, Luang Mall, which was issued on 29/12/2015. That in my Aadhaar card, I have mentioned my husband's name, Thang Hinglova, which was made by the Government of India. That the village council president, Luang Mall, Lunglei, also certified that my husband was living at Luang Mall. The VCP Luang Mall had given a certificate with his seal and signature, which is exhibited in the court. That I have stated that the opposite party, Zodin Pui, did not marry my husband, Thang Hinglova, but have 2 illegitimate sons. Both of them were over 30 years, and they were not entitled to get pension. Now, my Lord, this part has already been rebutted by the judgment of the Honorable Court, High Court, in the writ petition. that my husband Thang Hinglova made a will for me to get all his service benefits on date 29/6/2013 in the presence of witnesses who were which was registered number 699 of 2013 before the district registrar Lunglei and identified by the learned advocate Sri Arlal Rengpuya on dated 29/6/2013, which is exhibit in the court. That in the year 2014, my lord, this is important, in the year 2014, the opposite party's son, Lathan Puya, forcibly took the applicant husband to Aizawl and admitted at camp. During that time, the applicant approached the court. So, my lord, their ending was in 2014, when the son took the deceased forcibly, according to this person, my lord, and that was the end of their living together, my lord, 2014. Now, my lord, the certificates that she had mentioned, if I take to them, my lordship, I will first take your lordship to exhibit at page 12, exhibit P6. This is the voter's ID card she had mentioned. Page 12.
Page?
Page 12 of the paper book, my lord.
Yes.
Exhibit P6. Now, if your lordship will see, this is the voter ID of the respondent, but the date of the issuance, your lordship will see, the date of the issuance on the right side, 9/3/2015. This was after 2014, when the husband was not living with her, my lord. Then the Russian card that she had mentioned is at page number 15. Page number 15.
Yes.
Now,
also issued after
this was issued on 25/2/2016. Lordship will see the third box on the left side, 25/2/2016.
Yes.
Now, this was issued not only after 2014, my lord, but it was issued after Form 7 was made, that nomination form was made. It was issued after that nomination form was made.
Nomination was in whose name?
Nomination, my lord, GIS nomination, your lordship will remember, Form 7 I had mentioned.
Yes, it was in whose name?
In favor of the 4 children, and wherein the appellant was named as the wife.
What was the date?
The date of the nomination was, my lord, 18/1/2016. So this was almost like a month after, more than a month after. And my lord will come to page 31.
Exhibit D12, isn't it?
Yes, exhibit P12. That was exhibit P12.
This is at page 132.
Exhibit P12, yes. Exhibit P12 is the, my lord, is...
No, where's
is
that
in-
nomination? Form 7.
It's in that separate application we had submitted, Form 7. It's in a separate application, my lord, that's CMA. Yesterday, the first CMA number 17 of 2019.
CMA.
Exhibit D12. CMA number 70 of 2019, my lord. Yesterday, your lordship had, yes.
Okay, application before the...
Yes, for additional submission of additional documents.
What happened to this CMA?
It was allowed, my lord.
It was allowed.
As far as my knowledge is concerned, it was allowed. In fact, Exhibit D12 was one of the exhibits.
Form 7. This is dated 18/1.
18/1/2016.
Yes. Carry
Now,
on.
now page number 31, my lord. These are the other documents that she had submitted. Now, the first document, my lord, is her voter ID, which we have already examined, my lord. It was issued on 9/3/2016. Sorry, 15. Then your lordship will see the Aadhaar card on the on the right side. The Aadhaar card was issued on 3/10/2017, my lord. This was after the death of the deceased person. 3/10/2017. It's on the right side. It's circled, my lord. There is an old Xerox. I'm not sure if it's circled. Page number 31. Aadhaar card is there. Beside the name Vandal Pari, my lord, it is in horizontal, in vertical, sorry.
3/10.
3/10/2017.
This is the date of issuance.
This is definitely, my lord. And by this time, the deceased person had already died.
Then what about the other one? This is voter's
Then
ID.
there is one voter's ID of Thang Hinglova, my lord. The date is not legible from my copy, but it looks like it was issued on either 29/12/2015 or 20/12/2015.
From where you're seeing that?
My lord, on the right side, I can see something, my lord. It's not very clear. 2012/2015, I think.
Right side means where? Where the photographs?
Yes, where the photograph is, and on the right side of that particular photograph, my lord, on the second, here, my lord. My lord, here, my lord, here.
Not possible. Huh?
Not possible. That's the left side, my lord. I mean.
Plus, you know, they have stapled it. I mean, it's
Yeah,
clipped,
yes.
so you cannot turn that page.
It looks like it's 2015, though, my lord.
Half the pages cannot be opened.
Yes.
Anyway, according to this is also issued after his death.
Not after his death, after he left him. 2014, he was gone. The son took him, according to her. These things were issued after he left him.
Then how come they are in the hands of the appellant?
They are in the hands of the appellant because the appellant applied them by herself, my lord. In fact, that's what she said.
Not appellant, respondent.
The respondent. She had made these applications, my lord, in order to get these documents. It's a unilaterally applied by her. That's what I'm trying to say, my lord. As in fact, Aadhaar card was issued to her after he died, so it's not possible that he was privy to this Aadhaar card. Some of them were issued after the nomination was filed. These are the documents she is using, my lord, in order to show that she is the wife.
Yes.
And, but she also has, my lord, I'll take your lordship to two documents, page number 9. Page number 8 is the original and page number 9 is the English translation. This is the alleged Manhanna document. On dated 4/6/2011 Saturday, today, I have received rupees 420, the marriage price for the marriage between Thang Hinglo Rasel, son of Than Tsinga, Lungle and Vandal Pari Darbura, and rupees 20 is returned as for Thutpa. Now, according to this document, this was paid by Tit Lal Tlansunga in the presence of Lal Loma and Rual Kuma and received by K. Lal Ramoya. Now, my lord, I would like to mention that T. Lal Tlansunga K. Lalram Moya and Lal Loma were never called as witnesses.
What is serial number 2, the name?
Sorry, Madam, I think the spelling there is no spelling mistake actually. It's written wrongly in the original document also. It's Lan Loma. It's written Lan Loma.
No, Tan Loma. I think it's T.
Oh, sorry, my lord. There must
Tan
be T.
Loma.
Yes, Tan Loma. Yes, Tan Loma. Sorry, my lord.
They were not examined?
No, they were not examined. Ruwal Kuma was examined. But if your lordship will see the signature of Ruwal Kuma in the original document at page 8, it was signed the following day, not on 4. He was supposed to be the president of the village council.
Where is his deposition?
His deposition is PW number 2, my lord. His PW number 2 at page 109. Page number 109, my lord, I'll read it. That I am the applicant witness of this instant application of airship certificate number 66 of 2017, and I'm the village council president at Luang Wall during the year 2003 to 2011, 3 consecutive times for VCP. That I, applicant and her husband Thang Hing Lova, and I was present at the time of Manhlana on date of 4/6/2011 for the marriage of the applicant and her husband Thang Hing Lova, that the said Manhlana is already exhibit in this court, that the bride price is 420, only which is given by Tilal Tlanshunga, who was not called, on behalf of Tan Hing Lova and received by Kelaram Moya, again not called, in the presence of Tan Loma, who was also not called. The then President Young Mizo Association, Luang Mall President Lunglei, and myself during the time when I'm holding the post of VCP Luang Mall Lunglei. It is a fact that I was personally present during the time of Manhlana between the applicant and her husband Thang Hing Lova. But I did not bring my seal. Due to this, I gave my signature and put my seal on dated 5/6/2011. Now, my lord, even though he did not have his seal, my humble submission is if he was present, he could have at least signed.
Normally, one has to sign it.
Yes.
And seal you can take it later on.
Yes, you can put it later on.
Isn't it?
Yes, this does not make sense.
No, this is the explanation for the date, that's why.
Yes, correct.
Whether it's believable or not, it's a different thing.
Yes.
Explanation is that, okay, I did not bring the seal, so I did not put any signature.
Yes.
Well, he could have put his signature and get the seal later on.
That's true.
Anyway.
That the marriage between the applicant and her husband Thang Hing Lova is valid, and marriage certificate was issued by the competent authority under the Mizo Compulsory Registration of Marriage Act 2007, and the marriage certificate was already exhibited in the court. That the applicant is the legal wife of the deceased during the time when her husband was admitted at Christian Hospital Serkon Lunglei. The applicant take care of her husband and taking all necessary steps for the recovery of her husband Thang Hing Lova. The applicant reflected the name of her husband in all her official documents like voter ID card. Again here, my lord, they had mentioned this is a unilateral thing. The applicant reflected the name of her husband. It's not as if they both took this step, my lord. He also said the applicant reflected the name of her husband in all her official documents, like voter ID card, Aadhaar card, and other documents, and they were officially known as husband and wife in my locality, and I also witnessed they attend the church together, service together. That the applicant and her husband living together peacefully, and suddenly the applicant husband, 2 sons, came and physically tortured the applicant husband and threw his clothes in the dustbin in the presence of the applicant. And after that, the said applicant husband, Thang Hing Lova, was taken away by the said 2 sons. Due to this, the applicant approached me for help to search whereabouts of her husband and contacted the OC Kulikon Aizol for taking necessary action. Now, that's what he had stated, my lord. Now, in his cross-examination, my lord, 112, he had mentioned like this. Okay, my lord, I'll read from paragraph number 6. The rest of them, I'll read from 1 itself, my lord. It is a fact that I am familiar and clear with my examination in chief, which I have submitted before this court. It is a fact that I do not know how many paragraphs contained in my plaint. It is a fact that Srimati Varnal Pari and the deceased person Thanghing Lova informed me prior to witness their marriage by way of Manhlan, since we have friendship bond since long time ago. It is a fact that being a VCP at that time, I also witnessed their marriage by putting VCP seal. It is a fact that I do not know the statement herein mentioned in paragraph number 6 of my examination in chief. It is a fact that I do not know whether the deceased was taken to Christian Hospital, Serkon. Initially, she was saying she was taken to Serkon Hospital. I do not know what kind of disease was diagnosed to the deceased person, Thanghing Lova, but the cause of illness is due to alcoholism. It is also a fact that I do not visit the deceased Thanghing Lova in the hospital. It is also a fact that I do not saw any medical prescription letter of the deceased person, Thanghing Lova. It is a fact that the applicant Srimati Varnal Pari married to several persons before she married Thanghing Lova. It is a fact that I do not know whether the applicant Srimati Varnal Pari have divorce certificate or any documents regarding to the divorce of her previous husbands. It is a fact that the deceased person, Thanghing Lova, was died at Aizawl. It is also a fact that the applicant Varnal Pari was not present at the time when Thanghing Lova met his destiny. It is a fact that I do not remember the date when I give my examination in chief. So there is another point, my lord, that she has had several husbands, and there is no proof of her divorce with her previous husbands. The marriage certificate is there, my lord. Marriage certificate is, my lord, at exhibit P. My lord, at page number, page number 11, exhibit P3. Page number 11, my lord.
11?
Yes. This was the marriage certificate.
What is in persons of the memorandum dated so and so?
In persons of memorandum dated the 4th day of June 2011. Now in the first it says 2012, my lord.
What is this memorandum?
This one, my lord, is not clear. It says 2011, but if your lordship will see the top, it says 2012.
Where? The top?
Your lordship will see, if I read out, my lord, I, Lalbi Agni, so and so, it says like that, daughter of Sri Dar Bura, late on this 5th day of June, on the top, my lord, 2012, in persons of the memorandum dated the 4th day of June 2011. So, according to these people, my lord, he was married in 2012, June 2012.
No, the memorandum is 2011.
2011 memorandum.
So, what is that? That is Manhlanna, I think.
That must be the Manhlanna of 4/6/2011.
This, correct. So, the memorandum they speak about is regarding the Manhlanna.
Must be, my lord. But in
This
the...
is not issued by the church, it is by the registrar of marriages.
By the registrar of marriage. My lord, nowadays we know what happens. People go there. This was before the compulsory registration. People go there and they apply, my lord, I think. And if your lordship will come to page number 1, there is some incoherence. Page number 1 is the airship certificate application.
Yes.
There it says in second paragraph, the applicant married the deceased Thang Hinglova on 4th June 2011. The bride price was paid and registered on 5th June 2012. So this is, again, my lord, there is some incoherence.
Why not? How?
Because, my lord, first, in the bride price, if your lordship will see the date on which the bride price was...
4/6/2011.
Yes, but in this application it says the bride price was paid and registered.
No, they are separate.
Okay. No, they said they
The
were
bride
married
price
on
was
4th
paid,
June.
and that it was registered on so and so.
4th June 2011, and the bride price was paid and registered on... Okay. Yes. So anyway, my lord, what they have is they have this bride price document and the registration marriage certificate. In this respect, I have already pointed out, my lord, the people who had paid the bride price, they were not called as witnesses. That is one, my lord. And the second is, my lord, the letter dated 28/4/2016. That is Exhibit D3, wherein Thang Hinglova, my lord, he had specifically stated that they were not married. So this creates doubt, my lord, regarding whether there was actual marriage between them or this was a document that she had fabricated. And if your lordship will come back to her deposition, my lord. Her deposition in the cross-examination.
Where is that?
My lord, at page number 106, that's where it starts.
Now, tell me one thing. What was the reasoning given by the headship court to issue headship certificate to the respondent?
The
On what
impute
basis?
order? The impute order. First
On-
of
on
all, my
what
lord,
basis?
the first reason given, my lord, was that the signature of the plaintiff. Usually, what happens is, my lord, in a plaint under Order 6, Rule 14, I think, my lord. I'll take your lordship to that page later. It says that, my lord, every plaint has to be signed by the plaintiff. That's what it says. My lord, in the plaint portion, not in the verification affidavit, she had signed in the verification affidavit, there's no mistake. But in the plaint portion, after the prayer portion, my lord, her signature is missing. So he's not there. So that was one reason that he had given, that this counterclaim that she had filed is not acceptable. That's the first reason the judge had given.
Your counterclaim?
Counterclaim. Second is, my lord, the judge said that my marriage is not valid because, first of all, 125 application, that order, he says, is usually given only when there is a divorce and not otherwise. So that is the first assumption that the judge had made, that it is usually given because of when there is a divorce, but there was no divorce between us, no evidence of divorce. So that's the first.
No. You are saying that only when there's a divorce, then Section 125 of maintenance is given.
That's what the judge said, my lord, the law.
That's what the judge said.
Yes.
So, meaning thereby that there's a presumption that you have been divorced.
Divorced.
Is that the law? That only when
No.
one is divorced that 125 will come?
Not at all, my lord.
Is that a precondition?
No, not at all. The precondition is that I have to be a wife. That's the precondition. And I have not been able to maintain myself. That is the only condition. And a divorced wife is considered to be a wife.
A wife, but should it be a voidable marriage or void marriage or whatever?
If it's a void marriage, my lord, the question of 125 does not come into play. I'll take your lordship to that Supreme Court judgment. I've got it today. But if it is a voidable marriage...
No, let's clear our doubts now.
Yes.
Straight away. 125.
1 minute, my lord.
Okay, it is the child actually. It says his wife.
Yes,
If any person having sufficient means neglects to or refuses to maintain his wife,
yes,
unable to maintain herself, or his legitimate or illegitimate minor child,
yes,
whether married or not,
yes,
unable to maintain itself,
yes,
then his legitimate or illegitimate child, not being a married daughter, who has attained majority,
yes,
wherein by the such child is by reason of any physical or mental abnormality or injuries unable to maintain herself,
yes,
itself, or father or mother unable to maintain himself or herself.
yes.
These are the categories.
Categories. And the first
So
is...
it
is-
says wife,
Yes,
but it doesn't say whether it's a divorced wife or a...
correct. But, my lord, if your lordship will come to the proviso, to the explanation down, B, wife. Wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried.
So it only includes.
It only includes.
It doesn't say that it is only in a case when...
It does not say at all. But that's the presumption the court had made, my lord, that because we have 125, we must have been divorced.
So number one, the signature is not there in your counterclaim.
Correct.
Number two is that wife is not, the question of maintenance will come if you rely upon 125, is that only when you are one is divorced, that comes into play.
Yes.
So since 125 was given, that means you are divorced.
Correct.
And third point?
Third point is, my lord, the court had relied on these documents I had shown you, Manhanna documents, and also the marriage certificate, and
Marriage
said
certificate.
that her marriage is valid.
Manlanna, marriage certificate, then what about the other voters ID and all that, Aadhaar and
All
that?
of those things, the documents that she submitted and said they are valid. But the court did not refer to Form 7. My lord,
That
that
was not
nomination
referred.
was not referred.
Let us go to the judgment. Let's see.
Yes.
Is
And
it
also, my
lengthy?
lord, the court did not refer to one thing, my lord. I will take to lordship to the judgment, but in her cross-examination, she had admitted, my lord, that she was married to two other people, the respondent.
That you have just read.
Yes, yes. And that she has not divorced him. My lord, the impugned judgment is at page 140. I'll take your lordship to the findings at 142. The issues, I'll start from the issues at 142. And at this stage, my lord, I would like to point out these issues that the court had mentioned are different from the issues that were initially framed in the court, in the trial court. But anyway, my lord, issue number 6, at paragraph number 6, at page 140.
No, what do you mean in the trial court? This is the trial court.
Yes, my lord, initially what happened was in the trial court, there were some issues which were, one, the order is, and the order, my lord, there is an order of the lower court which has been...
No, which trial court?
Trial court in the original, where the airship, the Lunglei court, senior civil judge.
Correct.
Issues...
So, the judgment you're referring to here is passed by the senior civil judge.
Correct. But my lord, if your lordship
So
will
you're
turn-
saying that it is not, the issue framed here is not the one which is framed in the original trial court?
That's what it looks like, my lord. If your lordship will turn to 102.
102?
Yes, of the paper book.
What is 102?
My lord, this was the order of the lower court. 102.
No, 102 is a...
Page number 102.
Okay. What is this? This is issues.
These are the issues.
Issues framed?
Yes.
Do you have the LCR with us? Let us see. What is the date of this LCR?
This was issue. My lord, the next court date after this was 17/7/2019.
See, when
this was
they-
27/6/2019.
Just a minute. When they make the paper book, na, let them bind from somewhere here. It's difficult to turn page because out here you can't read. It should be somewhere in the end part, na? What is the date of the framing of issues?
It's 27/6/2019, my lord.
How many issues are framed?
3 issues were
Three.
framed.
Correct.
The first is whether the plaintiff is the legal wife of the deceased. Second is whether the plaintiff/defendant is entitled to receive the family pension and leave salary of the deceased Than Hinglova. Whether there is any document proof of the plaintiff to show that she is legal wife of the deceased. Then after that, Lordship 17.7 was fixed for evidence.
So what do you mean? This is not similar to in the judgment?
My Lord, this judgment, the issues were newly framed basically when the judgment was pronounced.
Where is the issues?
Now 142, my Lord. Paragraph number 6, it says like this, my Lord. Hence, considering the pleadings of both parties, the following issues are framed and amended from time to time under the provision of Order 14, Rule 5 of the Code of Civil Procedure 1908. So basically, the issues seem to have been amended, my Lord. But we are not privy of this amendment. Anyway, my Lord, the 3 issues that were framed, whether the written statement/counterclaim filed by the defendant/counterclaimant is maintainable or not. 2. Which one, the plaintiff or the defendant counterclaimant, is the legal and rightful wife of the deceased Than Hinglova? Who is entitled to the relief claim, the plaintiff or the defendant counterclaimant? In order to establish her case, the plaintiff examined as many as 5 witnesses, including herself, and the defendant examined 3 witnesses, including herself. Now, issue number 1.
Just a minute.
Yes, Lordship.
Have you checked up the order sheet as to whether such kind of amendment to the issues have been made?
I have not checked, my Lord, but if it's there, my Lord, we were not informed.
But you are represented, isn't it?
Yes, yes, yes.
It's not that this has been passed ex parte.
If it was done, my Lord, it would have been done right just before the judgment, because
So it was during the COVID times, lockdown and all that there. First final hearing. Today is fixed for defense and harbor. Problems to spread of COVID. Today is fixed. Issues are framed normally before the evidence. Before the evidence.
Yes.
So it cannot be just that before the judgment they start framing issues. Cannot be.
to my knowledge, my Lord, these were the only issues framed in the beginning.
Yes, there's no other issues, sir. As per the record,
yes,
it was only on 27/6/2019. And what does it say here? That it's as per the
Order 14.
Order
Rule 5.
14, Rule 5. Power to amend and strike out issues.
Yes.
The court may at any time before passing a decree amend the issues in frame or frame additional issues.
Yes. But the one thing we want to mention, my lord, and I'll take your lordship to one Supreme Court judgment later also. The first new issue which was framed, my lord, has prejudiced us because we weren't able to give this Supreme Court judgment to the court, the lower court, my lord. The signing, because there is a Guwahati High Court judgment, my lord, and also Supreme Court. Guwahati High Court judgment, my lord, specifically says that signing of the plaint is a mere irregularity, and if it does not hit the merits of the case, my lord, it should be ignored. We have provided the citation today. So, if we had the chance to present that judgment, my lord, I think it would have been different with respect to that issue. Counterclaim, my lord. Correct. But I want to point out one thing, my lord. Their application also does not have their signature, which was not mentioned. It should have been dismissed, their application also, my lord, if I'm not mistaken.
Where is their application?
Page number 1, my lord. It only has the council's signature. Page number 1.
What about the verification and affidavit?
That even ours was there, my lord, verification affidavit. The same thing. So we were.
Where is your counterclaim?
My lord, counterclaim is at page number 17. Sorry, 37. And the verification is there at page number 49 and 50, my lord. The affidavit is not included in this paper book. It's there in the original. Okay, it's there.
So there's no signature in page 49?
In 49 it's not there. The court had said that the plaintiff needs to sign here. But there also, their application also is not there. I don't know why they have not rejected, the court did not reject hers, but rejected ours only. In the view of the matter, my lord, that signature has become irrelevant because of this judgment of the Guwahati High Court in Kailash Singh versus Hiralal Dey.
What does the CPC provide for?
My lord, CPC has yes, pleadings. Order 6, Rule 14, my lord. It says like this: every pleading shall be signed by the party and his pleader, if any, provided that when a party pleading is by reason of absence or for any other cause unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defend on his behalf. Order 6, Rule 14.
So it has to be signed.
Correct. It says it has to be signed, no doubt, my lord.
Plaint was not signed?
Plaint was not signed.
Counterclaim also was not signed?
Not signed.
Counterclaim was rejected on this ground, but plaint was not rejected.
Not rejected.
In writ petitions, you don't give your signature, isn't it?
No.
There's an affidavit, that's all.
That's all. In fact, my lord, the judgment of this Guwahati High Court says that it is a mere irregularity, and if it does not...
Let us see.
Yes.
Judgment.
My lord, this is reported in 1993, 1 GLR 434.
In relation to plaint?
Plaint, pleadings, in relations to pleadings, my lord.
Kailash.
My lord, yes. Paragraph number 14 at page number 438. Paragraph 14, 15 and 16 are relevant. I'll start from paragraph number 14. Section 99 is very clear that no decree shall be reversed or substantially varied on the ground of no enjoinder of parties or causes of action or any error, defect or irregularity in any proceeding not affecting the merit of the case or jurisdiction of the court. Although according to Mr. Khetri, this section does not include signing and verification of the plaint, I am of the opinion that the expression any error, Defect or irregularity in any proceeding in the suit will also include signing and verification of the plaint as laid down in Rules 14 and 15 of Order 6 CPC. In this connection, attention of this court has been drawn by Mr. Sharma to a decision of the Punjab and Haryana High Court in Srimati so-and-so. In that case, the plaint and the verification was not signed by the plaintiff but by his lawyer. But the plaintiff in the witness box supported all the averments made in the plaint. The court observed that the counsel for the plaintiff was presumed to be acquainted with the facts of the case. So the verification of the plaint made by him can be accepted. Moreover, it is a defect which may not only amount to an irregularity, which only amounts to an irregularity and can be ignored for rejecting the plaint. It was also held that legal position is that want of verification has not the effect of making the plaint void, and it merely amounts to an irregularity. Regarding signing of the pleadings, although the High Court recorded that decisions are not uniform, the prominent view is that irregularity in signing of a plaint is a mere defect of procedure and does not affect the jurisdiction of the court. I am in respectful agreement with the above law laid down by the Punjab and Haryana High Court. In my view, we have come to a stage in our jurisprudence where we should not be tied down with procedural technicalities, but we should try to do substantial justice to the parties. In the case in hand, it would be unfair and unjust to reject the plaint merely on the ground that the plaint was not properly signed and or verified, as plaintiff himself came to the witness box and made out the case in the plaint. Below, my lord, it goes on and it says, I'll read from the 16. It may also be added here that Mr. Sharma has placed reliance on two decisions, namely so-and-so. In Dadia Bhai Supra, Honorable Chief Justice Chakla of Bombay High Court, as his lordship then was held, that if a plaint is not signed by a properly authorized person, prayer can be allowed for signing a plaint by the plaintiff even after limitation. In Bikaji Keshrao, the Apex Court, while considering Section 83(1) of the Representation of the People's Act 1951 vis-a-vis Order 6, Rule 15 CPC, held that even if there was absence of date in the verification of the election petition, it would be a good ground for dismissing the application, and normally the petitioner should be allowed to remove the lacuna by adding a supplementary verification. Though these two decisions are not directly on the point, I am only referring to these two decisions to show that provisions of Order 6, Rule 15 of CPC are not mandatory, but directory in nature. I therefore hold that Order 6, Rule 15 CPC is not mandatory, and any defect can be cured at any stage.
So, you should have been invited to cure the defect.
That's one, my lord. Or it should have been allowed both, because we had come to a witness box and we had pleaded the same things we had pleaded in our counterclaim, my lord.
Now, you should show me the judgment, impugned judgment.
The impugned judgment, my lord, at page number 142 is where the issue starts, my lord. The discussions. Page 142. And my lord, they have not mentioned, there is nothing that says, examines the application filed by them. Issue number 1. Whether the written statement / counterclaim filed by the defendant counterclaimant is maintainable or not. My lord, how can a written statement be maintainable or not maintainable? Admittably, the present written statement counterclaim has been filed by the defendant challenging the issuance of heirship certificate number 66 of 2017 in favor of the plaintiff via order dated 31st July 2017, issued by the Senior Civil Judge Lunglei District Court. Order 4, Rule 1 of this Code of Civil Procedure 1908 prescribes mandatory provision for institution of suits, which reads thus: suit to be commenced by plaint. Every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. Every plaint shall comply with the rules contained in Order 6 and 7, so far as they are applicable. The plaint shall not be deemed to be duly instituted unless it complies with the requirements specified in Sub-Rules 1 and 2. Order 6, Rule 14 of the Code of Civil Procedure 1908, parties are mandated to append their signature in the pleadings, which reads thus: pleadings to be signed. Every pleading shall be signed by the party and his pleader, if any, provided that when a party pleading is by reason of absence or for other good cause unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defend on his behalf. In the present case, the defendant counterclaimant fails to comply with the mandatory is not correct, my lord, mandatory provision under Order 4, Rule 1, as well as Order 6, Rule 14 of the Code of Civil Procedure 1908, that neither she nor her learned counsel have given their signatures in the pleadings. In the case of Sina Mani and others versus V. Vetivel and Orsas, decided on 9th May 2011 in connection with Civil Appeal number 4363 of 2012, the Apex Court has held that a suit can be instituted by presenting a plaint, and Order 4 and 7 of the Code of Civil Procedure deals with the presentation of the plaint and the contents of the plaint. When the statutory provisions clearly says as to how the suit has to be instituted, it can be instituted only in that manner alone and no other manner. Also in the case of Narmada Bachao Andolan versus State of MP and others, decided on 11th May 2011 in connection with Civil Appeal number 2082 of 2011, the Honorable in the Apex Court has laid down that it is a settled position of law that a party has to plead his case and adduce sufficient evidence to substantiate the averment made in the petition, and in case the pleadings are not complete, the court is under no obligation to entertain the pleas. Hence, consequent upon failure to comply with mandatory provision under Order 6, Rule 14, as well as Order 4, Rule 1 of the Code of Civil Procedure 1908, and with the above Honorable Apex Court decisions, this Court is of the considered opinion that the present written statement cum counterclaimant is not maintainable. In the result, the present issue is decided in a negative.
So this issue is basically regarding signature.
Signature.
This is Order 4, Rule 1. It refers to the Orders 6 and 7. Seven is regarding plaint. Order 6 is regarding the pleadings
in
generally.
general. So Order 6 is for written statement and also plaint. But their plaint, my lord, itself does not comply with this.
So according to this High Court, such an omission is, or to signing of the plaint is directory in nature, not mandatory.
Yes.
It's curable. Then issue number 2.
Even the Supreme Court says, my lord, I have the Supreme Court judgment, but I don't think I need to produce it. It's here. I have given a citation of the Supreme Court on this signing itself.
Who is that? Who is that?
Lordship, this was reported in 2005. I have given a printout. 1 minute. (2006). This was reported, my lord, in 2000, AIR 2006 SC 269.
269, paragraph?
Yes. My lord, the relevant paragraph is at paragraph number 16, 15 and 16. It's a curable defect. It can be cured at any time as per the Supreme Court judgment, even at the appellate stage when the court identifies the error. And in that High Court judgment, it says it does not even have to be cured, because if there is a witness who has come, if he has come as a witness, my lord, the judgment is there.
Supreme Court judgment, do you have that?
It's there, it's the printout is there. Lordship will come to paragraph number 16. Paragraph number 15, my lord. It is now well settled that any defect in signing the memorandum of appeal or any defect in the authority of the person signing the memorandum of appeal. Okay, my lord, I'll come to paragraph 16. I think it's more straight. An analogous provision is to be found in Order 6, Rule 14 CPC, which requires that every pleading shall be signed by the party and his pleader, if any. Here again, it has always been recognized that if a plaint is not signed by the plaintiff or his duly authorized agent due to any bona fide error, the defect can be permitted to be rectified either by the trial court or at any time before judgment, or even by the appellate court by permitting appropriate amendment when such defect comes to its notice during hearing. But my lord, there is that High Court judgment. It says that if I have come as a witness, it does not even have to be cured.
Okay, second issue.
Second issue, my lord. Issue number 2 at page 143. Which one, the plaintiff or the defendant counterclaimant, is the legal and rightful wife of the deceased Than Hing Lova? The plaintiff stated in her examination in chief on affidavit as PW1 that she had married Than Hing Lova on 4 June 2011 and bride price was paid and their marriage was registered on dated 5 June 2012. That their marriage register certificate was also issued by the competent authority and Manhlana letter was also made during the time. That after their marriage, they were living as husband and wife, living in the same house at house number 12 of Luang Mall, Lunglei. In support of her evidence, the plaintiff exhibited their marriage certificate as Exhibit P3, Manhlana as Exhibit P4, family ration card as P5, voter ID of herself as P6, voter ID of the deceased Than Hing Lova as P7, her Aadhaar card as P8. In her cross-examination, PW1 stated that she know Pusinga, her previous husband, that he is not Mizo, that she did not have any evidence to show that she has been divorced with Pusinga, that she also know Puzika, that she had lived with Puzika in her house and that she was not married to Puzika, and that she was also married to Puzika and that she did not have any evidence to show that she was divorced to Puzika, and also that she does not have any evidence to show that the defendant was divorced with the deceased Than Hing Lova, that the defendant had 2 children out of the wedlock with the deceased Than Hing Lova. 14. R. Rual Kuma of Luang Mall, Lunglei is examined as P2 and stated that he was village council president of Luang Mall for 3 consecutive periods from 2003 to 2011, and during that time he was present at the time of Manhlana on dated 4/6/2011 for marriage of the present plaintiff and her husband Than Hing Lova. That the bride price Rs 420 was given to T. Laltlan Tsunga on behalf of Than Hing Lova and received by KL Rammoya in the presence of Tlan Loma, the then president Young Mizo Association, Luang Mall branch, Lunglei. That he was personally present during the time of Manhlana between the applicant and her husband, Than Hing Lova, but he did not bring his seal. Due to this, he gave his signature and put his seal on dated 5/6/2011. PW2 exhibited Manhlana as Exhibit P1 and his signature and seal as Exhibit P1A. In his cross-examination, PW2 stated that Srimati Vanalpari and the deceased Than Hing Lova informed him prior to witness their marriage by way of Manhlan, since they have friendship bond since long time ago, and that being a VCP at that time, he also witnessed their marriage by putting VCP seal. PW2 further stated that the applicant Srimati Vanalpari married to several persons before she married Than Hing Lova, and that he did not know whether Srimati Vanalpari had divorce certificate or any documents regarding the divorce of her previous husband. Lomzwala and Lal Thang Liana Li deposed similar evidence as PW3 and 4 respectively by stating that they were personally present at the time when the bride price of rupees 420 was given by T. Lal Tlanshunga on behalf of Than Hing Lova and received by KL Ramoya in the presence of Tlan Loma, the then President Young Mizo Association Luangmol Branch Lunglei and R. Rual Kuma at Luangmol Lunglei on dated 4/6/2011, and they know that the applicants Srimati Vanal Pari and Than Hing Lova were married and lived together at Luangmol Lunglei. In his cross-examination, PW3 stated that the bride price was given by Tlanshunga and Dal Chakkima and received by Chuan Moi and Dal Ramoya, while PW4 stated that she did not know whether the bride price was paid or not. PW5, the Tsiingi of Lunglon Lunglei, stated in her examination in chief on affidavit that she know the applicant Vanal Pari and the deceased Than Hing Lova, and the deceased was her paternal cousin. It is a fact that the deceased Than Hing Lova and the applicant Srimati Vanal Pari were married, and the applicant is the legal wife of the deceased Than Hing Lova. In her cross-examination, PW5 stated that the deceased Than Hing Lova is her second cousin from her paternal side and have blood relation, and she do not know the place where his dead body was buried, that the applicant and the deceased were married on 4 June 2011, but she was not present at the time of marriage and she is not aware who has issued the marriage certificate. Whereas the defendant Zodin Pui stated in her examination in chief on affidavit as D1 that she got married to the deceased Sri Than Hing Lova in accordance with the Mizo customary law Mantlan, and that they had 3 children in the said wedlock. During their marriage, they had innumerable fights and disagreement as her deceased husband had acute alcoholic dependency problems. This addiction problem of her late husband created an unhealthy living environment for her and her children, which left her no choice but to leave him and live separately with her children. However, there was no judicial separation or any form of separation in accordance with the Mizo customary law. DW1 further stated that her deceased husband Than Hing Lova continued to provide maintenance to her in accordance with the court order dated 21/3/2011 passed in criminal complaint number 99 of 2009. Before the death of her husband, they began to live together again as husband and wife, that the applicant was not even present when he was sick or at the time of the funeral of her deceased husband, that she was the one who took care of her husband and that the death certificate was issued to her. DW1 further stated that to her knowledge, the applicant has a husband and that in wedlock with her husband, she has some children and that has not legally divorced him. In support of her case, DW1 exhibited a number of documents like her written statement cum counterclaim as Exhibit D1, signatures in the verification affidavit as Exhibit D1A and D1B respectively, that certificate of the deceased as Exhibit D2, maintenance order passed by JMFC as well as Exhibit D5. My Lord, let me stop here for a moment. My Lord, Lordship will see the exhibits that the court considered. This was D1, D2, and D6.
D1 is signature, what is this?
The counterclaim, my Lord. And D1A and D1B are her signatures. Then D2 is that maintenance order, my Lord. And D6 is the JMFC ISOL order, the maintenance order. D2 is the death certificate, JMFC ISOL order is D6.
Who was the defendant? You were the defendant?
I was the defendant.
Okay. So, these are your documents. DW1?
Yes.
No. D1?
Yes.
D1, D1A, D1B. These are your documents?
These D1A, D1B are my signatures in the written statement cum counterclaim. Then D2 is the death certificate and D6 is the maintenance order.
D1 was considered?
D1 is considered?
D1A, D1B?
Correct.
D2?
Yes.
Then?
D6.
D6.
Now, my Lord, we'll come to paragraph number 26.
D6 is regarding that maintenance.
Maintenance. The court did not consider any of the other documents. These, like form number 7 was not considered, RTI reply was not considered, the letter dated 28.
No, you had said that the maintenance was not considered, 125.
Considered, no, only maintenance was considered, but the court said since that was past ex parte, my Lord, since that was past ex parte without the presence of the husband, it has no value. In essence, that is what the court said. But the husband complied with that order, my Lord, and not challenged it. For many years, when he was living with the respondent, I mean, during that entire period, he was complying with that order. So it's not as if he did not agree.
D1, D1A, D1B,
D6,
D2, then D6.
Yes.
which leaves out
D3, very, very crucial evidence, my lord, letter dated 28/4/16. D4 and D5 are the RTI applications. D8, WPC order, GIS was already given. The D9, the will. D10, probate application order. D12, my lord, D11, D12, they are the form number 7. So, official records. No, actually, my lord, I think there's a mistake. At page 150, my lord, D9 and D10 were considered. That will was considered at page number 150. Page number 150, paragraph number 28. In the bottom, D9 and D10 were also considered.
What is D10?
D10 is, my lord, the order passed in the probate.
Probate?
Yes, at page 66. That's a judgment and order, my lord.
Page number?
66 of the paper book. The operative portion is at page number 69.
So what was the discussion regarding the will?
It says like this, my lord. It's paragraph number 29 at page 150, my lord. On careful examination of documents exhibited by the defendant, like maintenance order passed by the court of JMFC Aizawl as Exhibit D6 and probate order as Exhibit D10, it is found that both the court orders were an ex parte order in which no defendant has contested both the cases. That's the basic reason why the court did not accept. Well, just because it's ex parte does not mean it's not a, it should be ignored. And paragraph number 30, my lord. On plain reading of the court order as extracted above, it is evident that the present defendant has filed criminal complaint under section 125 of the Code of Civil Procedure 1908 against the deceased Thang Hing Lova on 24/8/2009, and all the summons issued to him were received, and he was fully aware of the existence of the case against him. That after almost 2 years, the concerned court decided to proceed the case ex parte since the defendant Thang Hing Lova willfully neglect to contest the case. 1 minute. There is a discussion on this part. My lord, at paragraph number 34.
Of the judgment?
Yes, of this judgment at page 153, my lord. Further, in view of the maintenance order passed by the court of JMFC Aizawl, White order dated 21/3/2011, it is well known that no wife had never claimed maintenance allowances from their husband under the provision of Section 125 CRPC as long as they are still living as husband and wife, but the said provision is usually put in motion in order to maintain destitute women and children who were neglected and refused to maintain and looked after by their ex-husband and father. They're saying that only by ex-husband and father, my lord. That divorce, my lord, I think it's not mentioned. I'm sorry, my lord. By mistake, I had mentioned the divorce. So this is the reason why the court did not accept the maintenance order to show that she's the wife and also the will.
So after all, what was considered here is this will was considered.
Will was considered?
D9.
Yes.
Then-
D9 and D10 is the order. Yes, D10 was considered. Then D6 was considered. D2 was considered, and D1 was considered.
Probate is in your favor.
In my favor. And it was mentioned in our counterclaim also. They knew it from the beginning, from the inception itself. But they did not challenge it.
What is the finding of the trial court on probate?
In probate, my lord, at page number 66.
No, obviously, probate was allowed.
Probate was allowed, my lord.
No, what I meant was the heirship court.
The heirship court the heirship court, my lord, said that probate is not valid because it's ex parte. The finding of the probate court, the heirship court is at.
What was left behind? GP fund, but this doesn't speak about the pensionary benefit, I mean the family pension, isn't it?
It talks, my lord, the first one. The pension.
Okay. 100%.
And he mentioned specifically Kanupui, my wife.
And in the judgment, impugned judgment?
Impugned judgment, my lord, it is not at paragraph number 29, 150, page number 150. On careful examination of documents exhibited by the defendants, like maintenance order passed by the court of JMFC or Azol on as D6 and probate order as exhibit D10, it is found that both the court's order were an ex parte order in which no defendants has contested both the cases. That's the observation. Because it was ex parte and not contested, the court seemed to have not thought it was not reliable. It was not reliable.
The abstract is from the maintenance order.
Yes, because the court was considering both the maintenance order and the probate order together, my lord. Exhibit D6 and Exhibit D10. D6 is the maintenance order and D10 is...
D10. Court Master, is it possible to lower the temperature a bit? This is 24 or something. 20? Check out the others also. Only one will not do. It's quite warm in here. So according to the trial court, you have failed to establish your case beyond all reasonable doubt.
Yes. That's the problem also, my lord.
There's enough burden on you.
Yeah.
You have to prove beyond reasonable doubt.
Beyond reasonable doubt, my lord. That's too civil case, my lord. And after ignoring Form 7 and all of these things. My lord, honestly, I think beyond reasonable doubt also, I think my client was the wife at one point. And even his client, my lord, I think there would be a probable reason to say, my lord, from the documents that there is a chance he could prove. But beyond reasonable doubt, my lord, the burden is too heavy.
I mean, that perhaps would be required in a criminal case.
Criminal case.
Not in a civil case.
Ours is preponderance of probability, my lord. That's why I'm saying probable. No one can prove, my lord, beyond reasonable doubt.
So you have to pay how much?
10,000, my lord.
As
Because we made the objection.
And 5,000 as court
As court fee. So we were made to pay fine also, my lord.
Okay. Anything else?
So, my lord, we have some Supreme Court judgments, my lord.
Regarding?
Basically, my lord, our humble submission is there are two things. Firstly, my lord, presumption is in our favor as a wife, and that presumption is strengthened by all the documents we have submitted, my lord. No doubt we have not filed the marriage certificate and the Manlanna certificate, my lord. But again, those documents were misplaced by the mother, and she had clarified during cross-examination. With presumption of marriage in favor of the second wife, my lord, we are saying that there is a presumption, but the presumption has been rebutted specifically by the letter dated 28/4/2016, wherein the deceased Thang Hinglova had specifically said that she is not the wife. And also because of the other supporting documents which were submitted by her, my lord, they were not reliable according to us. In documents like the Aadhaar card, the voter ID, and all of these documents. And the marriage Manlanna certificate she submitted, the witnesses were not called to testify in court, especially the person who had paid the bride price and the person who had received the bride price. They were not called as witnesses. So their presumption, my lord, has been rebutted by all of these things. And my lord, the third one we would like to state, my lord, presuming, my lord, that both the marriages were valid, since as per Section 10 of the Mizoram Marriage Inheritance of Property Act, my lord, Section 10 specifically says that second marriages are not valid if you have a spouse living and you have not yet divorced. So it's void ab initio as per Section 10, my lord. Section 10 of the Mizoram Marriage and Inheritance of Property Act is there.
Give me the act.
Section 10, my lord. Void marriages. So when people get married, there are two types which are not valid. The living together as husband and wife of A, two persons of the same sex, B, a person with another person having a spouse living, and C, either or both are under age, are void ab initio. So we come in that B, a person with another person having a spouse living. So if both the marriages, for the sake of argument, my lord, are not rebutted and they are valid, then the second marriage would have to be naturally considered void ab initio as per this section of the Mizo Inheritance and Property Act. Lordship, I'll take you to the meaning of void ab initio.
But is that not the case that the appellant and the deceased were not married?
That's their case.
That's their case.
But we are saying, my lord, based on all, firstly the presumption, and all the documents we submitted, Form 7, maintenance order, their legal notice, my lord, wherein she admitted that we were once married. All of these documents, my lord, shows that I was definitely married to the deceased person. There is no doubt, my lord, I was married. And she is saying that I was divorced. That was the basic claim she made in her entire case, that I was divorced with my previous husband. But there is no document of divorce. And so my marriage is definitely valid. And in fact, Form 7 and that probate order, my lord, Form 7 was before he died, Thang Hing Lova. In his nomination, he had specifically accepted and mentioned that I was married, I was the wife. In fact, that same Form 7, my lord, was also accepted by this honorable court. And based on that Form 7, my lord, judgment and order was pronounced in WPC. Number 217 of 2016.
Yes.
And the defendant and the court, my lord, adopted a standard beyond any civil court's standard, my lord, beyond reasonable doubt. It's not possible. And my lord, secondly, I want to point out, my lord, I was not the first husband of the respondent. I was, as per her evidence, the third husband. And there is no divorce certificate with the first two husbands. So that itself also will attract Section 10, my lord. On multiple grounds, the marriage between her and Thang Hing Lova would become void ab initio.
No, you are not the husband, you are the wife.
Sorry, with Thang Hing Lova, their marriage with Thang Hing Lova.
I'm not the third husband.
Sorry. And CCS conduct rules, my lord, Rule 21 also says the same thing.
Yes.
CCS conduct rules, my lord, Rule 21. I have provided the list of books, my lord. I think it will be there. CCS conduct rules, my lord, Rule 21. It says like this.
Yes.
I'll read out, my lord. No government servant shall enter into or contract a marriage with a person having a spouse living, and no government servant having a spouse living shall enter into or contract a marriage with any person. So he's not allowed to enter into a contract with any other person, provided that the central government may permit a government servant to enter into or contract any such marriage as is referred to in Clause 1 or Clause 2, if it is satisfied that such marriage is permissible under the personal law applicable to such government servant and the other party to the marriage. My lord, Mizo customary law has never allowed for bigamy. And B, there are other grounds for doing so. The first one has to be divorce, my lord. There has to be a proper divorce, and then he can remarry, my lord. In our case, there was no divorce with the appellant. In fact, he lived with her again before he died. So the second marriage, my lord, is not just void ab initio. It is a restricted marriage, even as per the CCS conduct rules, my lord, 1964.
What has happened to the process of pension?
It has been halted, my lord.
It was initiated initially?
Initially initiated.
In whose favor?
My client's favor. That's why when RTI reply also was made, they had stated that there was no divorce between me and the husband. So according to their official record, everything I am the wife. In fact, when he died, the department also paid money to me, my lord. So the department itself acknowledges that I am the wife.
Yes, anything else?
My lord, one Supreme Court judgment, this was in Yamuna Bhai, reported in 1988, one Supreme Court cases 530. This was regarding section 125.
Page?
Page 530.
Paragraph?
Paragraph number 1, 2, I will not read 1, 2, but 1, 2, 1, 2, 3, 1, 2, 3. But my lord, I'll start from paragraph number 6, reading.
Read.
The attempt to exclude altogether the personal law applicable to the parties for consideration also has to be repelled. The section has been enacted in the interest of a wife, and one who intends to take benefit under subsection 1A has to establish the necessary condition, namely that she is the wife of the person concerned. This issue can be decided only by a reference to the law applicable to the parties. It is only where an applicant establishes her status on relationship with reference to the personal law that an application for maintenance can be maintained. Once the right under the section is established by proof of necessary conditions mentioned therein, it cannot be defeated by further reference to the personal law. Now, my lord, in this respect, what I would like to say is 125 can only be granted if I am the wife. My lord, that is what I'm trying to say, that if I was validly married, if the court accepts it, then only I can get 125. I have been receiving 125, and the defendant, the deceased, was also not challenging that order. He complied with that order under section 125. He accepted I am the wife. And this case, my lord, also talks of my lord, if your lordship will turn to one paragraph, my lord, let me just read this out to show your lordship the impact of a void ab initio marriage. My lord, this is at page number 354. Of this same judgment, my lord, page number 534. 534. My lord will see in the first paragraph on the third sentence, my lord, the marriage. The marriages covered by section 11 are void ipso jure, that is void from the very inception, and have to be ignored as not existing in law at all, if and when such a question arises. In our case also, my lord, void. There is another judgment of the Supreme Court, my lord, which I will also take your lordship to. Void ab initio marriages, my lord, have to be considered non-existent, and that no declaration is necessary.
The marriage is covered by section 11.
Section 11 of the Hindu Marriage Act.
What is section 11? Do we have the Hindu Marriages Act? Oh, it's here. 11 is at page 533.
Yes. any marriage solemnized after the commencement of this act shall be null and void, and may, on a petition presented by either party thereto against the other party, be so declared by decree of nullity if it contravenes any one of the conditions specified in 1, 4, and 5 of section 5. And then first one, clause 1 of it lays down, for a lawful marriage, the necessary condition that neither party should have a spouse living at the time of the marriage. A marriage in contravention of this condition, therefore, is null and void. So even in Hindu marriage, just like Mizo marriage, my lord, it's null and void. And then it says, such marriages are to be ignored as not existing in law.
Okay.
And there is one other judgment, my lord. I think this is the 2000, I think I have given it, my lord, 2010, 9 SCC 209.
2010?
9 SCC 209.
This is regarding?
Presumption of marriage, my lord. Paragraph is at paragraph 24. Paragraph 24. The courts have consistently held that the law presumes in favor of marriage and against concubinage. When a man and woman have cohabited continuously for a number of years, however, such presumption can be rebutted by leading unimpeachable evidence, my lord. In our case, they have not led any evidence against our marriage. In fact, my lord, the only evidence that is unimpeached, my lord, is the evidence that they are not married because of the letter dated 28/4/2016. And one other judgment, my lord, this is reported in 2002 SCC 431.
2002?
2000 Volume 2 SCC 431.
This is again regarding?
This is regarding two wives claiming for pensions. And in this case, the Supreme Court had said the second wife is not entitled to the pension because in their personal law it is not accepted, but the children of the second wife are entitled. My Lord, at page 433, I'll read the brief facts, my Lord, at paragraph number 3. The dispute concerns payment of family pension and, my Lord, at paragraph 3. The dispute concerns payment of family pension and death cum retirement gratuity to two wives of Narayan Lal, who died in 1987 while posted as Managing Director, Rural Development Authority of the State of Bihar. The appellant is the first wife. Narayan Lal is stated to have married second time to Maya Devi on 10/4/1963 while the appellant was still alive. From the first marriage, he had got one son, and from the second marriage, 4 sons, born in 1964, 1971, 1972, and 1973. Learned single judge in his judgment held that the children born to Narayan Lal from the wedlock with Yokmaya Devi, that is the second wife, were entitled to share the family pension and death cum retirement gratuity, and further that family pension would be admissible to the minor children only till they attained majority. He also held that the second wife, Yokmaya Devi, was not entitled to anything. Appeal by but the first wife, Rameshwari Devi, against the judgment was dismissed by the division bench. According to her, there was no marriage between Narayan Lal and Yokmaya Devi, and the children were therefore not legitimate. Aggrieved Rameshwari Devi has come to this court. Now, my Lord, we'll come to paragraph number 10. Mr. Dubey, counsel for Rameshwari Devi, submitted that inquiry conducted by the state government as to the marriage of Narayan Lal with Yokmaya Devi, that's the second wife, was incompetent as there was no lawful authority with the state government to hold such an inquiry. It was for Yokmaya Devi to establish her right of her being married to Narayan Lal in a court of law. Mr. Dubey said that under the relevant conduct rules applicable to Narayan Lal, he could be charged with misconduct of his having married a second time during the lifetime of his first wife. It is only in that circumstance when there is a charge of misconduct there could be an inquiry as to the marriage of Narayan Lal and Yokmaya Devi. He referred to Rule 21 of the CCS Conduct Rules as well as to Rule 23 of the Bihar Government Service Conduct Rules 1976, which are as under CCS rules. Rule 21, restriction regarding marriage. No government servant shall enter into or contract a marriage with a person having a spouse living.
that you have already read.
Read. And my Lord, in this case, what the court said, my Lord, that departmental inquiry, because he has already died, and at the time of when he was still alive, since there was no departmental inquiry, there was no need for that kind of thing to be done, my Lord. But the court also mentioned section 494 IPC, my Lord, which talks of bigamy, my Lord, punishment for bigamy. And finally the court said, my Lord, that the second wife is not entitled to the pension because the marriage with the second wife is void ab initio.
Then what did the learned single judge?
Basically, it upheld the judgment of this learned single judge.
Learned single judge held that the children born from the second wife are entitled to the family pension and death cum gratuity.
Correct.
And what about the first wife?
The first wife is entitled to the family pension.
So they share?
So they share in this case. But the second wife, because it's a restricted marriage, cannot enjoy it.
Children can enjoy?
Children can enjoy.
But not the wife?
Not the wife. Illegitimate children can enjoy.
In the present case, there's any children
No
involved?
children. No children.
From the second wife? No.
No. Okay. Two wives can enjoy, my Lord. There are certain cases where two wives can enjoy, but only if both the marriages are legal. For instance, the first one was divorced, or for instance, it's a Muslim marriage, my Lord. Let's say a Muslim, and they have permission to get married 2 times. Then in such cases, 2 wives can enjoy.
Okay.
My Lord, there's one last
Is it not enough?
No, just one last, just to explain to your lordship, my lord, there was one judgment I have on the issue of void ab initio, my lord, just one paragraph, my lord, only one paragraph. This was reported in 2001, 6 SCC. Sorry. Five 37, I think, my lord.
What is the paragraph?
2001.
The paragraph.
Yes, relevant paragraph, my lord, is at paragraph number 22. Because in our case, my lord, the court, as per section 10 of the Mizo Marriage Inheritance of Property Act, such marriages are void ab initio. So, my lord, void ab initio has been explained at paragraph 22, the second sentence, the third sentence, the third line. One type of void acts, transactions, decrees are those which are wholly without jurisdiction, ab initio void, and for avoiding the same, no declaration is necessary. Law does not take any notice of the same, and it can be disregarded in collateral proceedings or otherwise. So, my lord, in ours also, what we are saying is the second marriage has to be considered non-existent, even though there is no declaration that she is not married. So, with that, my lord, my humble prayer is that this judgment should be set aside and we should be given a relief. The prayer of the appellant should be allowed.
Okay. Yes.
May please, Your Lordship. Your Lordship, we have 10 minutes more. I don't know whether may I proceed or not. Your Lordship may look so tired.
What do you mean 10 minutes more?
Lord, before 4 p.m., Your Lordship.
What is the court timing?
No, Lordship, usually that court arrives around 4 p.m. If you're, then I'm okay with that, Lordship. Because I may take long, Lordship. This is our RFA.
I think the court time is until 4:30.
Okay.
That doesn't mean that we'll continuously sit till 4:30. It depends on the situation.
Lordship, yes.
How long should you take?
I may take long, Lordship. My learned friend had take 2 days for a hearing. At least 1 day is required. Yesterday and today, almost the whole day.
5 hours.
Yeah.
You can start, no problem.
Lordship, yes. Lordship, first of all, I would like to say that, Lordship, the issues framed by the learned trial court, which my learned friend had already read out, which is at page, Lordship, in the judgment, in the paper book. Issues framed by the learned court. Lordship, at page 142. There are as many as 3 issues, Lordship.
Yes.
Lordship, may I read?
What do you say about these issues?
Lordship, yes, this
originally, originally the issues were different.
Yes, Lordship.
There's been amended.
But there is a provision under Order 14.
No. Provision is there, no doubt.
Lordship,
that we have
yes.
already read. And thing is that, are you aware about the changes in the issues?
Yes.
Or the court on its own had amended the issues?
Lordship, this, I'm not sure regarding that, Lordship, whether that was informed
Otherwise,
to
the case record does not reveal anywhere that it was changed at any point of time,
Lordship,
except in the judgment.
But it clearly says that considering the pleading of both the parties, because from the reading of the evidence adduced by both the parties, the main issue was who is the legal and rightful wife of the deceased. That is the main issues. But in the earlier issues framed by the learned trial court, that was not clearly specified. And here in that issues, whether the written statement counterclaim filed by the defendant counterclaim is maintainable or not, is included in this this belated later issue. But earlier it was not there. So I think there is nothing wrong in this later one, Your Lordship, later issues framed by the learned trial court.
Okay. Yes, please continue.
Your Lordship, and the first point my learned friend had said is regarding the Order 6 Rule 14. Order 6 Rule 14. So it may be true that the defect may be cured during the proceeding of the trial, Your Lordship. And the appellant failed to take any steps in order to cure the defect, Your Lordship. So they have a sufficient chance during the proceedings of the case, then that mistake or that things could not be, Lordship, grounds in that appellate court, Lordship, because they have a sufficient chance. And regarding the issues framed by the learned court, the point number 2 is the appellate, this trial court had framed these particular 3 issues, and they say that they do not know those issues. But it is not the duty of the court to inform the appellant that these are the issues framed by the court. Instead, they have to ask the court what are the issues framed by the court, and based on that issues, they have to lead the evidence, Your Lordship. But my learned friend had said that this CCS Conduct Rules 1956 and Form 7 pertaining to Group Insurance Scheme 1992, that was not the issues for determination before the trial court, Your Lordship. Because the learned trial court cannot go beyond the issues framed by himself, Lordship. So if the appellant is not satisfied with the issues framed by the learned trial court, then they have they may approach the learned trial court saying that we are not satisfied with these issues framed by the learned trial court, and this may be at or by filing the application before the learned trial court.
No, see, those things are part and parcel of that issue.
Yes.
Like supposing issue number 2, say which one of the plaintiff, which one? The plaintiff or the defendant is the legal and rightful wife of the deceased.
Yes.
So in order to come to that conclusion, all these aspects has to be explored. What is the documents relied upon and exhibited by the party, and whether that same is an admissible evidence or permissible in law. So those aspects can be looked into. Does not necessarily mean that issue has to be framed, whether the CCS conduct is applicable or not. Otherwise, there will be more than 40, 50 issues framed.
And besides, Your Lordship, the learned trial court had used the same yardstick because it appreciated all the evidence, Your Lordship. And from the reading of the evidence adduced before the learned trial court, and there is no evidence to show that this is the CSS, this is a Form 7 and whatnot, Your Lordship. That was not adduced before the learned trial court. Whatever they have stated before the learned trial court was regarding the this bride price and all, Your Lordship.
No, Form 7 was exhibited.
Exhibited, but there is no evidence lead on that exhibited documents, Your Lordship.
Exhibit D12, that's Form 7.
D12. And besides, Your Lordship, may I take Lordship to page 148. 148. From paragraph number 25, Your Lordships. May I read, Lordship? In the present case, both the plaintiff, petitioner, and the defendant counterclaimant has claimed that at the relevant point of time they had married the deceased Thanging Lawa in accordance with the Mizo customary law, Manhlan, and claimed to be the legal and rightful wife. In support of her claim, the plaintiff petitioner exhibited the marriage certificate as Exhibit P3, Manhlanna, Exhibit P4, family ration card, Exhibit P5, voter ID of herself, Exhibit P6, voter ID of the deceased Thanging Lawa as Exhibit P7, and her Aadhaar card as Exhibit P8, whereas the defendant counter-claimant exhibited her written statement and counterclaim as Exhibit D1, her signature in the verification part as Exhibit D1A, her signature in the affidavit as Exhibit D1B, death certificate of Exhibit D2, copy of maintenance order passed by GMFC, isolate Exhibit D6. On careful examination of available evidence on records with documents exhibited by both the parties it is evident that the plaintiff that she had married Thang Hing Lova on 4th June 2011 and bride price was paid, and the said Manlanna is exhibited as Exhibit P4, that their marriage was registered as the Mizoram Compulsory Registration of Marriage Act 2007, Exhibit P3, and they were living as husband and wife and living in the same house, number 12 of Luangmo, Lunglei. Being husband and wife, she had reflected the name of Thang Hing Lova as husband in all her documents like family ration card, voter's ID, Aadhaar card. On careful analysis of the said Manlanna Exhibit P4, it is written in vernacular language and produced as Manlanna voin date nili tharuk sang ni som pakat inrin ni hian Thang Hing Lova sha sel son of Thang Chinga lunglon le vanal parit daughter of Darbu Kalet in nei na man cheng zali som ni kadonga cheng som ni thut pha atan ka kire. This paragraph number 27. On the basis of the above Exhibit P4, the bride price was paid on 4/6/2011 by T. Lal Than Chunga and received by K. Lal Ram Moya in the presence of Tlan Loma and R. Rual Kuma, the then president of Young Mizo Association and Village Council Luangmo Lunglei, and further on the basis of evidence adduced by Rual Kuma as PW number 2, he was personally present during the time of Manlanna between the applicant and her husband Thang Hing Lova, but he did not bring his seal, and due to he gave his signature and put his seal on 5/6/2011, and he was exhibited his seal and signature as Exhibit P1A. Further, on the basis of another documents exhibited by the plaintiff like marriage certificate, family ration card, voter's ID, and Aadhaar card, the name of the deceased Thang Hing Lova is reflected as husband of the plaintiff. Whereas the evidence of the defendant is that she got married to the deceased Sri Thang Hing Lova in accordance with Mizo customary law, Manlan, and they were living as husband and wife and had 3 children in the wedlock, that as her husband had acute alcoholic dependency problems, they used to have innumerable fights and disagreement, and finally she had left him and lived separately with her children. However, there was no judicial separation or any form of separation in accordance with the Mizo customary law, and that her deceased husband continued to provide maintenance to her in accordance with the court order dated such and such, passed in criminal complaint number such and such, that before the death of her husband, they began to live together as husband and wife, and that the applicant was not even present when he was sick or at the time of the funeral of her deceased husband, and that she was the one who took care of him, and the death certificate was issued to her. In support of her case, the defendant exhibit a number of documents like her written statement cum counterclaim, such and such, that is already read out. On careful examination of the documents exhibited by the defendant, like maintenance order passed by the court of JMFC Aizawl as Exhibit D6 and probate order as Exhibit D10, it is found that both the court orders were an ex parte order in which no defendant has contested both the cases, wherein paragraph number 2 of the maintenance order of the JMFC Aizawl order dated such and such does read out, the respondent did not attend his court dates even once, despite receiving all the summons issued to him and despite being fully aware of the existence of the present case. This application was filed on 24/08/2009, and since the respondent has never appeared in court till date, his continuous absence is hereby taken as willful negligence on his part, and accordingly, this court is heard and determined ex parte. On the plain reading of the court order as extracted above, it is evident that the present defendant has filed criminal complaint number under section 125 of the CRPC, should be CRPC, 108 against the deceased Thang Hing Lova on 24/8/2009, and all the summons issued to him were received, and he was fully aware of the existence of the case against him. That after almost 2 years, the concerned court decided to proceed the case ex parte since the defendant Thang Hing Lova willfully neglected to contest the case. However, in the present case, both the plaintiff and the defendant counterclaimant have claimed that they were getting married with the deceased Thang Hing Lova in accordance with the Mizo customary law Manhlan, and therefore, while careful consideration about this case, this court carefully perused the Mizo customary law, Mizo Namdan, which was published in the Mizoram Gazette such and such, wherein section, Lordship, this Mizo customary law, this published and notified in 6/4/2005 should be applicable in present case, Lordship, not 2014 case, Lordship. Mizo Namdan Bung Thum Nupui in Nei Thu, Chang Som Thum Paruk in Nei Chung Chang in Nei Nupa, Meichia Le Mipa Puitling Nupui Pasal Pumlai Nei, Lo Veve, Palai Manga Mipa Chung Tele, Meiche Chung Te, in Berema Man in Lana, in Nei Tir Te Tu in Ain Nei Tir Te in Nei Ania, Chutiang Chau Chunupa Ani. Note number 1, in Nei Hi Nule Pa Te Veve in Biak Remna, Sa Koin Anem Het Trinani, in Nei Tir Te Tu Sorkar in Emo, Tu Nei Tu in Emo, Arwat Apiang in Nei Tir Tu Ani, Manhlanna, and Nupa Chiar Telo, in Lukung Emo, in Fanemo, in Ruemo, Tlan Dun Emo, Te Chu, Eng Chen Po Nupa Anga, Dunin Fa Te Po Nei Hiel Ma Se Chang Som Thum Paruk, Pakhatna in Asoy Angin in Nei Ani, Lo Chuan Nupa A Chiar Te Ani Lo. Lordship, in this regard, may take back Lordship to page 139, paragraph number 4 and 8, DW number 3, page 139, Lordship. Page 139, that's a DW number 3, Lordship. Yes, paragraph number 4. It is a fact that the deceased Thang Hing Lova and the defendant Zhou Din Pui did not have any marriage solemnization in my knowledge. Number 8, it is a fact that the deceased Thang Hing Lova and the defendant Zhou Din Pui were blood related. Due to this, the family did not accept the marriage between them before giving the said bride price. They were married secretly. Lordship, in this regard, this Mizo Namdan Bung Tum Chang Som Tum Paruk clearly says that in Nei Hi Nule Pate Veve in Biakremna Nem He Turani, in Nei Tir Te Tu Surkarin Mo Tu Nei Tu in Mo Arwat Apiang in Nei Tir Tu Ani. Lordship, the Mizo customary is very clear in this regard, Lordship. So there is no solemnization, and the marriage was not accepted by the parties, the family members of the.
What do you mean by solemnization?
Solemnization means, Your Lordship, that may be solemnized as per our customary law, Lordship. Maybe in the church also.
Church is not customary law.
The church, Your Lordship, that has to be solemnized, Your Lordship. Solemnized means in that bolpu, and that was available there in our Mizo customary law. Bolpu or sadot, something like this, no? I'm not sure that was.
Whether Manhlanna is solemnization?
It's not a complete one, Your Lordship. There is a decision court ruling also, Your Lordship.
It is not a complete one?
Yeah, it's not a complete one.
When will it become complete?
Because I think that will be solemnized. Solemnized, it's quite clear in my mind, but it's very difficult to express, Your Lordship. Because that Manhlanna is not a complete one, Your Lordship. That was
so Manhlanna is not sufficient?
It's not sufficient, Your Lordship, in order to complete the marriage as per the.
So how was the marriage complete in your case?
Lordship, that
you have that Manhlanna letter.
Yes, I have.
You have that?
Yes, I have
and
that.
And you have the marriage certificate?
Yes, I have that.
But where is the solemnization?
Solemnization, because, Your Lordship, this without solemnization, that marriage certificate never issued to the parties.
No, but the marriage certificate doesn't say that. You just come back to that certificate.
Marriage certificate.
Where is that page? Page 11.
11.
It's in pursuance to the memorandum. So it appears that Manhlanna paper was prepared.
Prepared, Lordship.
And then with the witnesses and all that, and the person who received it, the person who gave it, and on the presentation of that letter or memorandum, this certificate was issued.
This certificate was
Isn't it?
No,
Or
sir,
is
yes.
it your case that your marriage was solemnized by way of any Christian rites anyway?
Lordship, as per my understanding, this is enough for the complete marriage, Lordship. Because manlanna only is not a complete marriage, Lordship, in the eye of law. Because there is a coordinate bench judgment, Lordship, which says that it's not complete.
Okay, if it's not complete, then what will make it complete? By getting one certificate?
No, Lordship. That here it says that it should be pala, Your Lordship. Here it clearly says that. Lordship, that bung thum that which I have already read out, chang som thum parok. It clearly says that in hinule pa in biak remna. That in biak remna is required, Lordship. And in nei tier thei tu sarkar emo thu nei tu emo aruata piang in nei tier tu. That is a competent authority for marriage is a government or any authority appointed by the competent authority, Lordship. And as per my understanding, that is done on my part. And it was missing on the part of the appellant. And that was the grounds taken by the learned trial court, saying that as per the Mizo customary law, the marriage between the alleged marriage was not completed, Your Lordship.
Please read the first, chapter 36, subclause 1.
English translation? Lordship?
You read the Mizo version.
Mizo, yes, Lordship. Mi pala imhechia puitling nu pui pasal pomlai nei lo veve palai manga mi pa chung tele meche chung te in berema man in lana in nei tir thei tu in ai nei tir hi in nei anni. Lordship. Tu tiang chau chu nu pa anni. But Your Lordship, what is missing in this case is, as per the evidence adduced by the DW number 3, that family did not agree.
See,
and besides
the first part is there, because both the families have come to a consensus.
Yes, Lordship.
They have approved the marriage, so that bride's price was paid.
Lordship, yes.
Second thing is regarding the marriage they're being married. In nei tir thei tu in ai nei tir hi.
Lordship, yes.
In nei ani. In nei ani. So
in nei tir thei tu is at note number 2, Lordship.
So whether this note number 2 was performed in your case or not?
Yes, it was performed because marriage certificate was issued, Lordship, which is a page.
No, marriage certificate was issued on the basis of memorandum.
Lordship, that was a competent authority to issue a marriage certificate. So it is reliable, Lordship.
No. See, the memorandum referred to here in the marriage certificate is dated what? 4th of June 2011. Your man in Lanna is also 4th of June 2011. So it refers to this only. So that's why I asked you the meaning of solemnization. Somebody has to take both of your hands and get you married somehow.
But Your Lordship, there is no evidence that both the parties are not agree. But in my case, both the parties seems to be agree about the marriage between me and my deceased husband. But in that appellant's case, it was not agree because that was in the evidence by the DW number 3 also. So that was discussed by the learned trial court, Lordship, and came into the conclusion that the marriage between the appellant and the my deceased husband was not completed.
Okay,
so,
we'll talk about his case later on. Let us talk about your case.
Yes.
In your case, you have presented the marriage certificate,
Lordship, yes,
which refers to a memorandum dated 4th of June.
4th of June.
2011.
Lordship, yes.
And if you go back to the Maninlanna, this is also dated 4th of June 2011. So somebody came from the groom's side, handed over the 420,
Hmm.
and 20 rupees was taken back,
Hmm.
as now popcorn or whatever you call it.
Yes.
And then there were witnesses, 1, 2, 3,
Hmm.
and that's all. After that, what you did? On
Lordship,
5th of June 2012, you went and got the certificate.
Lordship may take Lordship to the evidence adduced by the bridesmaid, which is a
Bridesmaid.
Bridesmaid, yeah, Lordship, yes.
Okay, let's see. Well, that is PW?
PW, Lordship number 4, if I'm not mistaken, 117. Not 117. Yes, Your Lordship, 117. Lordship, the operative is at page 118, paragraph number 3. May I read, Lordship?
Yes.
That I know the applicant Vanlal Pari and the deceased Than Hing Lova and the deceased Than Hing Lova. I am the bridesmaid of their marriage on dated 4 June 2011, and I put my signature in the marriage certificate form during the time when the said marriage was registered on dated 5th June 2012. The bride price is rupees as and such, only which is given by T. Laltan Chunga on behalf of Than Hing Lova and received by Kela Ramoya in the presence of Tlan Loma, then the then Waime President Luangmo branch Lunglei and R. Rolkuma at Luangmo Lunglei. That it is a fact that I am personally present during the time of Manlana between the applicant and her husband Than Hing Lova on dated such and such. I know that the applicant Srimati Vanlal Pari and Than Hing Lova were married and lived together at Luangmo Lunglei.
Now, how were they married? This 4th June of 2011 is Manlanna. So, this has been considered as marriage.
Yes, Your Lordship, this is one of the mandatory Lordship, as per my understanding. Because Manlana
see,
is...
for example, if one is a Christian, the Manlana takes place on one date, marriage takes place after 1 day or 2 days or the next day, whatever. Then registration comes later on. And the church also may give some registration certificate. But here, this registration is not by the church, it's by the, under the Mizoram Compulsory Registration of Marriage Act 2007. So, the solemnization part would be perhaps in the church.
Perhaps in the church, Lordship, yes.
Now, she says that she's the bridesmaid.
Lordship, yes.
And she put her, she said they got married on 4th of June 2011.
Lordship, yes.
So there's no certificate to that effect issued by the church, that they were married
Lordship,
in church?
It's not in the record, Lordship, that
Perhaps there is nothing like that. That is why they have relied upon only this Manlanna and registration. Registration happened after 1 year.
Lordship, yes, after 1 year. Yeah, it's the date shows that it's after 1 year.
And after 1 year, the bridesmaid also, she went and put her signature.
Then she said that she
I
was
put
present.
my signature in the marriage certificate form.
On, Lordship, on, yes.
So there must be a form. Who wants to apply for the marriage certificate? The bride,
Yes, Your Lordship,
the
yes,
bride, the
yes.
groom will give their
Yes,
signature.
it-
The
it's
bridesmaid
there.
and the best man also will give their signature.
yes.
They'll apply, fees paid, then they'll issue
Yes, yes.
certificate. And as a proof of their marriage, I think this
Certificate was issued.
Manlanna was given, that memorandum. So after seeing that Manlanna, he issued the certificate. Anyway,
Lordship, that was, it may take back, Lordship, to page 149. Oh, 150, Lordship. I apologize, Lordship.
150.
150, wait, Lordship.
This is the judgment.
Yes, Lordship, should be 150, 153, Lordship. Already read out.
153.
153, paragraph number 33.
Paragraph 33, yes.
Pardon, yes. In the present case, both the plaintiff and the defendant counterclaimant have claimed that they were getting married with the deceased Tan Hing Lova at the relevant point of time.
They were not married, they were getting married. So both
Yes,
of you are not married.
That's it.
Okay.
That in support of her case, the plaintiff exhibited Manlana as Exhibit P4 and marriage certificate number such and such issued by the marriage registrar of the local area, Luangmul, as Exhibit P3, while the defendant counterclaimant fails to exhibit any marriage certificate or Manlana in order to establish that her marriage to the deceased Tan Hing Lova was actually solemnized and regularized in accordance with the Mizo customary law or any other law for the time being enforced. In fact, the document exhibited by the plaintiff, like family ration card, voter's ID, and Aadhaar card, are official documents used to prove the identity and address of the card holder in various schemes under the government of India and the government of Mizoram as well. Here in this paragraph 33, it clearly says that I have produced that Manlana and marriage certificate, but on the other hand, the appellant is not able to produce Manlana or any marriage certificate in order to establish that they were married, Lordship. So weightage is on my part, Lordship, in this regard.
What happened was they got separated at some point of time. So the wife was not very happy. So she kept the documents away. She gave it to somebody. Later on they came back together. Yeah. So that's why she misplaced it.
But misplaced, it may be an excuse made by the appellant, Lordship. We never know. Because I'm having the documents I produced before the court, then that makes a weightage before the tribunal, before the trial court, Lordship.
Correct.
And paragraph number 34, further, that in view of the maintenance order passed by the learned JMFC Aizawl White order, it is well known that no wife had never claimed maintenance allowance from their husband under the provision of 125 CRPC as long as they were still living as husband and wife, but the said provision is usually put in motion in order to maintain destitute women and children who were neglected and refused to maintain and look after by her ex-husband or father. Also, my understanding in this regard is, while we are married, no maintenance was given. When we divorce or we neglected or maybe we are stay away or separated from my wife, and in that situation, 125 CRPC is put in motion, Lordship. This is what the learned trial court is trying to say in this regard, Lordship. So, under 125 CRPC, which clearly says that the appellant and my deceased husband are already separated, so because of that reason, 125 CRPC was put in motion, Lordship. So, which means that they are not husband and wife, Lordship. And with regards to the defendant counterclaimant's submission that the parties were once again living as husband and wife, and the defendant took the dead body of the deceased in her residence for funeral and death certificate was issued, defendant does not prove that they were married in accordance with the Mizo customary law. So death certificate was issued to the appellant does not mean that they were married. And once they may be living together as husband and wife, that is also, Your Lordship, denied by us, denied by the respondents, Your Lordship. Because here the evidence says that the sons of the appellant took my husband forcefully, Lordship. That was already read out by my learned friend. So because of that,
So the three, how many children? 3 children or 4 children? 3? 4.
Lordship, in this regard.
So 4 children are all illegitimate children, if there was no marriage.
Lordship, in that, choose not take away.
There was a case, writ petition regarding that GIS and all that. He did not contest. So he accept that these are the children of the deceased person and the appellant.
Yes, Your Lordship, 2 of them are, may I take, Your Lordship, take back to 147, Lordship.
2 of them only?
2 of them, as per our understanding.
2 of them
Another 2 are from the different, husband. The appellant also married with another guy, Lordship, Rosama of Venglai Lunglei, Lordship. And out of the said wedlock, the other 2 children were born.
Where is that in the evidence?
Lordship, which is at 147.
147?
Lordship, yes.
Of the judgment?
From the judgment, Lordship. Paragraph number 22. The learned counsel for the plaintiff further argued that the defendant counterclaimants Srimati Zodin Pin, the deceased Than Hing Lova, had 2 children without getting married, that out of her 4 children, the only 2 elder children, namely Lal Thanpuya and Lal Fakzola, were born between her and the deceased Than Hing Lova, and the other younger 2 children, namely Emily Lalrempui and Lalremruata, were born out of the wedlock with another person, Rosama of Venglai Lunglei. But in order to claim pension or service benefits, she has fabricated their birth certificates by reflecting the deceased name Than Hing Lova as their father, and she continued to lie before this court regarding the number of children she have with the deceased Than Hing Lova. That in her examination in chief DW number 1, she submits that she and the deceased Than Hing Lova had 3 children, but in cross-examination she had stated as having 4 children with the said Than Hing Lova. The defendant counterclaimant and the deceased Than Hing Lova were close relatives, sharing same blood relation, and her parents did not allow her to get married with Than Hing Lova even after giving birth to the 2 children, which is taboo before the eye of public and Mizo customs, Your Lordship. So, Your Lordship, as I have stated here, Lordship, the issues is who is the legal and rightful wife of the deceased, and this regarding the CIS and that form number 7 is not the issues for determination before the learned trial court, so it was not considered. It was rightly not considered, Your Lordship. If that is in the issues, then it may be considered, Your Lordship. But that is not the issue. For consideration before the learned this lower court, there are as many as 3 issues, and it has been discussed and it has been clearly reflected the reasons and the findings thereof, Your Lordship. So that is and regarding the alleged will, Your Lordship, the alleged will, my learned friend had stated that it was later probated ex parte, Lordship. In this regard, this heirship application was filed by the present respondent in the year 2017, Your Lordship. Lordship, page 17.
A petition to object the counterclaim made by the opposite party.
Lordship, yes.
This is filed by you?
Yes, filed by me, Lordship. Because counterclaim was submitted by the appellant.
By way of miscase or what?
Miscase.
The cause title says miscase.
Yes.
Huh?
It's, I think counterclaim maybe page 37. Let me see.
Where's the counterclaim?
At page 37, Lordship.
37 is the counterclaim.
Yeah, it's a counterclaim.
It should have come after the counterclaim, isn't it?
Yes, yes. It's,
Objection has come before the counterclaim.
it's wrongly placed here, Lordship. It's,
But what about this miscase? Why does
Lordship,
it say
I think
miscase?
it may be wrongly reflected. It should not be a miscase. It should not be a miscase, Your
There is
Lordship.
no separate miscase?
Yes, yes. It's not necessary to file in the separate application because the objection is regarding the written statement cum counterclaim.
Counterclaim is not registered separately?
No, it's not required.
Not
As far as my knowledge is concerned, Lordship. Because
What
when we
about,
have
what about cross appeal?
cross appeal
Is registered?
Yes, needs to be.
Cross
I think-
appeal is still
yeah, cross
registered?
appeal needs to be, yes, needs to be. And cross objection also needs to be registered.
Even if the appeal is dismissed, cross appeal has to be decided separately?
Yes, yes, Lordship, yes.
But in case of counterclaim, not required?
I think
One
our usual
nomenclature
practice is we
one
never
nomenclature
register
is
separately.
good enough.
Hmm.
Then, okay,
Then I have filed the objection to the written statement cum counterclaim filed by the appellant. That's it.
see, if you come to, this page 17 is the objection to the counterclaim.
Yes, Lordship.
Then if you come to page 19, what do you understand by paragraph 10?
Paragraph 10, that the applicant husband made a will in favor of the present, because Your Lordship, another will is also executed by my deceased husband in my favor, Your Lordship. But unfortunately, that was not probated, Your Lordship. But that was exhibited. Which is at page 36, Your Lordship.
36.
Yes, Your Lordship. Which is exhibited without any objection before the trial court.
Where's the original copy?
Lordship, original, only the translated one is in the paper book, Your Lordship. I'm sorry.
Just give this file to Mr. Johnny.
Yes.
Come here. Give this file to us. You ask your friend there to locate the Mizo version. Original one. Who will?
Will.
Exhibit P11. Time really flies, is it? I thought it was going to be around 4 o'clock now.
Interesting case, that's why, my lord.
No, since you took 2 days, he says, so he also wants to take 2 days. So if you get 1 share, he also will get 1 share. So both wives are very insistent, persistent. So this means that you also had a will in your favor.
Yes, Lordship.
So I was thinking of the will which Mr. Joseph was referring to. So there's another will
There's another will.
in your favor.
Yes, in my favor.
So that's why I was thinking, how come it is there in his objection? Not objecting to the will, but simply saying there's a will.
Lordship, I have located. May I read? Or?
Yes.
There's two roads here. Gaitan Hing Lova, son of Tanching Alate, AAI Agriculture, Department of Government of Mizoram Thokla Hian, Voin date Nisom Nipani, June, Sang Nisom, Patum Hian, Gotoro Chia Nungber, and Noemi Ang Hian Kasiame. Kanupui F. Vanal Pari, daughter of F. Darbura, late residents of Luangmua Lunglei, Mizoram Hian, Kanei Ro Eng Kim, Anei Vekanga, Adu Danina en Kolang, Kamang Anle, Buaile Damlo na Kato, Reng Rengin Kanupui F. Vanal Pari Bak, Tuma in Min, Boy Puin Min en Kolongailo of Vangin, Zankat Mitchin, Kalautok, Anipoin Kanupui F. Vanal Pari Hian, Kapenson benefits Zong le, family pension at Changvek Turania, Karo Akhom Chungchanga, Tuma in Anchu, Boy Turanilo, Hek at Huro Chian Hunung Berhi, ka service book a ka nomination zong ain alal zok tur aniti hi ka du danani he ka thuro chia tinghet tur hian vo inisom ni pakwa jun sang hi som pathum hian ril ru fim takin keima thu ngein thu shetu pani ma ka zia kani and it was
okay, but you're not pressing this, isn't it?
Lordship, I'm
you do not
pressing,
press you do not press this will in the heirship certificate case. You just merely exhibited it.
Exhibited, and besides that, Lordship, because that Turauche is not the issue, because the issue here is who is the legal wife and rightful wife of that is Tang Hing Lo. That's why evidence was laid based on that. But the parties, not only me, but
Turauche is connected to you being the legally wedded wife, because he says that my wife, so and so.
Yes, yes.
So you have to rely upon this.
And here it says that Turauche Nungber. He ka service book ka nomination
more than one will.
And it was registered as per the Indian Registration Act, Lordship. That is
the will.
The will, Lordship.
Okay,
yes.
but it was not probated.
It's not. It's not probated, but it was registered under the Indian Registration Act. So, registration number is also reflected here.
All right, we'll do one thing. We'll have to continue. I think you still have some more to submit.
Yes, Lordship. Yes.
Tomorrow, I don't know how much things.
Lordship, if your Lordship permits me, let's continue on Monday, because I have personal difficulty tomorrow, Lordship.
Acha, tomorrow you have difficulty?
Tomorrow, Monday, Lordship.
Mr. Joseph?
No issues, my lord.
Please write, hearing remains inconclusive. List the matter again for further hearing on 24th of March 2025 in the Part 1 cost list.
Yes,
Can you just flag that part?
Sure.
That will. This item 8 and 9 was your matters.
Yes, my lord, if these matters can come up after a week. 8, 9, and 11, my lord, in fact.
Okay, please write as prayed for by Mr. Joseph L. Bentley, learned counsel for the appellant. This is the matter again after a week. Item 8 and 9. Okay, in item 11, similar order, but you'll write his name as not appellant, but for petitioners.